The HOA Karen disabled my wildfire defense system. Her street burned first. The fire marshal standing in my driveway told me something I'll never forget. Your system could have stopped it at the tree line. Behind him, 3 houses on Pinecrest Lane were still smoking, all of them belonging to HOA board members who'd voted to tear my equipment down. 6 weeks before the fire, Sandra Hollis had my wildfire defense sprinkler array declared an unauthorized structure and ordered it dismantled by county contractors. She smiled at me from across the street while they pulled the pipes from the ground. I took a photo of that smile. I still have it. The night the Ridgeback fire jumped Route 9, I was at my sister's place 10 miles east. My house, the one Sandra said was bringing down property values with its safety equipment, was the only home on our ridge that didn't lose so much as a shingle. The system I'd secretly rebuilt held the line. Sandra's did not. My name is Daniel Marsh, and I've lived on Ridgeback Ridge in Sycamore Pines, California, for 11 years. I bought this property because of the view and despite the risk. A half-mile of dry chaparral between my back fence and the national forest, and a HOA that came with the deed like a bad inheritance. I'm a civil engineer by trade, semi-retired at 52, which means I have both the knowledge and the time to obsess over problems most people don't think about until it's too late. My wife, Carol, calls it my disaster hobby. She's not wrong, but she's also the one who reminded me to buy extra propane the week before the Thomas fire in 2017. We raised 2 kids in this house. The back porch has height marks carved into the door frame going back 9 years. I planted a valley oak in the yard when my son Marcus was born, and it's taller than the roofline now. When I tell you I would do anything to protect this property, I mean that in the most literal engineering sense of the word. Sycamore Pines HOA was managed like a small fiefdom, and Sandra Hollis had been its queen for going on 7 years. She'd run unopposed 3 straight elections because the people who might have challenged her had quietly learned that Sandra had a long memory and a longer list of CC&R violations she could suddenly start enforcing. Sandra was 61, a retired real estate agent, and she lived in the largest house on the ridge, a 4,200 square foot stucco and tile situation with a 3-car garage and a ring of Italian cypress trees she'd planted specifically to block her neighbor's mountain view. She had called it landscaping. The neighbor had called it war. Sandra had won. The HOA's Architectural Review Committee, which Sandra chaired and effectively staffed with 2 close friends, Brenda Kowalski and Ron Feltner, had the authority to approve or reject any exterior modification to any home in the 47-home community. Decks, paint colors, satellite dishes, mailbox styles. Everything ran through Sandra. I'd had my first real run-in with Sandra in 2019 when I painted my front door a shade of green called Forest Canopy. She sent a violation letter within 48 hours citing a color palette document I'd never been given at closing. I repainted. I chose Sage Mist. She approved it without comment, like a queen granting clemency. What I didn't tell Sandra, what I didn't tell anyone on the board, was that during those 11 years I'd been quietly educating myself on wildfire behavior, defensible space, and structure ignition mechanics. I'd taken 2 FEMA certification courses online. I'd read every post-fire assessment from the Camp Fire, the Woolsey Fire, the Dixie Fire. California's fire seasons had been getting worse every year. We were in a pattern now where catastrophic was just the baseline, and every August I watched the smoke columns build to the east and calculated how long it would take a crown fire moving at 8 miles per hour to reach our ridge. The answer was never comfortable. In 2021, I designed a residential wildfire suppression system for our property. It wasn't flashy, a series of buried irrigation lines running along the roof perimeter and the west-facing fence line, fed by a 2,500-gallon storage tank I'd sunk into the hillside, with a pump triggered by a heat sensor array mounted on the fence posts. The whole system could run for 45 minutes at full pressure without drawing from the municipal line, critical because municipal pressure drops to almost nothing when firefighters are working a wildland interface fire and every hydrant in the area is open simultaneously. I'd learned that from a CAL FIRE after-action report. I applied for a building permit in March of 2021. The county approved it in 6 weeks, underground tank, pump housing, and all the sensor mounts. The permit was posted in my kitchen window per code. I started installation that April, doing most of the work myself on weekends with my neighbor Tom Cafferty helping on the trench work. Tom lived 2 doors down and had a similar mindset about risk. He was a retired firefighter from San Bernardino County, 22 years on wildland crews, and when I showed him the system design, he walked the whole property and then said, "I'd have added a secondary pump, but this'll do." I added the secondary pump. The system took 4 months to build. By August 2021, it was fully operational. I ran a test with Tom watching, triggered the sensors with a heat gun, and watched the roof perimeter sprinklers activate within 6 seconds. Tom nodded slowly and said, "You're going to be the only house standing someday." I laughed. I shouldn't have laughed. For nearly a year, nobody from the HOA said anything about my system. The components along the fence line were low-profile, gray PVC, flush-mounted sensor housings, nothing that screamed unauthorized structure. The tank was underground. The pump housing was disguised as a utility shed that I'd gotten approved separately. What broke the silence was a neighbor 3 houses up, a new arrival named Garrett Phelps, who was trying to sell his house and had brought a real estate agent through who'd asked about the industrial-looking equipment on the marsh fence line. Garrett, rather than explaining it, had complained to Sandra. That was in February of 2022. Sandra sent me an email the following Monday. The subject line was HOA inquiry, unapproved exterior modifications. The tone was polite, almost friendly, which I'd already learned to treat as a warning sign. She asked me to clarify the nature of the structures along my west fence and confirm compliance with current architectural guidelines. I responded within the hour. I attached the county permit documentation, the system design overview, the CAL FIRE material I'd used as reference, and a brief explanation of how the system functioned and why. I was thorough. I was collegial. I think I even said something like, "Happy to walk you through it in person if helpful." She did not respond for 11 days. When Sandra's response came, it was not an email. It was a formal written notice on HOA letterhead, hand-delivered to my door by Ron Feltner, who had the grace to look slightly uncomfortable while I read it. The notice informed me that my fence line equipment had been reviewed by the Architectural Committee and found to be non-compliant with Section 4.7 of the CC and RS governing exterior structures. Section 4.7 covered freestanding structures exceeding 12 inches in height without prior ARC approval. Sandra was classifying my sensor mounts, which were 8 inches tall and attached to the fence, not freestanding, as violations. She was also citing the pump housing as an unapproved outbuilding, despite the fact that I had assigned approval for it from her own committee dated 18 months earlier. I called an attorney that afternoon, not because I was panicking, but because I knew Sandra well enough by then to understand that this wasn't a compliance inquiry. This was a test of how hard I was going to push back. And I intended to push back in the most expensive, well-documented way possible. My attorney, a sharp woman named Priya Desai who specialized in HOA disputes, reviewed my documentation and told me I was in an unusually strong position. The permit was valid. The prior ARC approval covered the pump housing. The sensor mounts didn't meet the definition of freestanding. She sent a response letter to Sandra's attorney. Yes, Sandra had her own HOA attorney. Within a week, the dispute sat in legal back and forth for 2 months. During that time, Sandra began what I can only describe as a campaign of selective enforcement. 3 of my neighbors received violation notices for things that had existed in the community for years, a basketball hoop, a garden arch, a decorative weather vane. Coincidence, Sandra would later say. It was not coincidence. Tom Cafferty came over one evening in April with a six-pack and told me that Sandra had been going door to door, describing my system as an eyesore and suggesting it was a liability risk because of the underground tank. She'd told at least 2 neighbors that it might leak into the water table. There was nothing to leak. The tank held water. What I didn't know yet, what I wouldn't learn until much later, was that Sandra had a personal financial stake in keeping the neighborhood visually uniform. She was quietly working with a developer named Craig Witowski on a plan to convert several Sycamore Pines properties into a luxury short-term rental cluster. Visible industrial equipment on a fence line would complicate the listing photos. I attended the April HOA board meeting and presented a 10-minute summary of the system's function, its county permit status, and its alignment with California's current defensible space recommendations. I brought printed copies of the relevant Cal Fire guidelines. I was calm. I was prepared. Sandra listened with the expression of a woman hearing a noise she intended to have removed. After I finished, Sandra thanked me for my presentation and called for a vote on whether to refer the matter to the HOA's legal counsel for further review. The vote was 3-2. Brenda and Ron voted with Sandra. The 2 independent board members, a quiet man named Phil Okafor and a retired teacher named Luz Martinez, voted against. Phil caught my eye on the way out. He shook his head slightly. The legal referral turned out to be a delay tactic. For 6 weeks, nothing happened except attorney letters, and then in June Sandra escalated. She called a special meeting of the full HOA membership, all 47 households, to vote on whether to formally classify my fire suppression system as a prohibited structure under an amendment to the CC and RS she was proposing on the spot. The meeting was held on a Tuesday evening in the community room of the clubhouse, which smelled like carpet cleaner and old coffee. Sandra had brought a printed agenda, a PowerPoint presentation, and what appeared to be a professionally designed handout. I had not been told a handout would be distributed. I had not been told there would be a PowerPoint. Sandra's presentation was slick. She'd pulled photos of my fence line, telephoto shots, angles that made the sensor mounts look larger and more intrusive than they were. She had a quote from a landscaping expert about aesthetic continuity. She had a paragraph from an insurance industry newsletter about unauthorized residential water systems. She had done her homework. What she did not have was anything from Cal Fire, anything from the county fire department, or anything from the building and safety division that had issued my permit. She also did not have Tom Cafferty, who stood up when she finished and said, in a voice that carried 22 years of wildland firefighting, "With respect, Sandra, you're describing a system that could save every house on this ridge." Tom's intervention shifted the room. I watched people who'd been nodding along with Sandra's presentation begin to glance at each other. A woman named Denise Farrow, who'd lost a friend in the campfire, raised her hand and asked Sandra directly whether she'd consulted with any fire safety professionals. Sandra said she'd reviewed the relevant literature. Denise pressed. Sandra changed the subject. The vote that evening was 22-19 in favor of not adopting Sandra's CC&R amendment. It was closer than I would have liked, but it was a win. I drove home feeling, for the first time in months, like the system was safe. Carol had dinner waiting. I told her we'd won. She hugged me and said, "Don't celebrate yet. She knows me too well." Sandra did not concede. Within a week, she had circulated a petition among the 19 who'd voted with her, plus a few fence-sitters she'd apparently worked on individually. The petition asked for a second vote, citing a procedural argument about whether the original meeting had been properly noticed. It was nonsense, but it was the kind of nonsense that could drag on for months. Priya reviewed the petition and told me Sandra's procedural argument was thin at best. But she also warned me that if Sandra kept pushing, the HOA's own legal costs would eventually become a factor. And some boards had a habit of pressuring the individual homeowner to compromise just to end the expense. I told Priya I was not interested in compromising on fire safety. In July, Sandra made a move I hadn't anticipated. She contacted the county building department directly and filed a complaint alleging that my underground tank installation had not been properly inspected and might constitute a grading violation. It was a lie. The tank had been inspected at 3 stages of installation, and I had photos of every inspection. But it generated paperwork. A county inspector named Hector Ruiz came out the following week. He was professional and thorough. He reviewed my permit, my inspection records, and the installation photos. He walked the fence line. He checked the pump housing. At the end of the visit, he told me everything was in order and that he'd be noting the complaint as unfounded in the system. He also said, quietly, "You're not the first person on this street I visited because of a HOA complaint." He didn't name names. He didn't need to. The unfounded determination didn't slow Sandra down. It seemed to energize her. In August, she sent a letter to every household in Sycamore Pines, personal stationery, not HOA letterhead this time, describing my system as potentially hazardous and suggesting that the underground tank posed unknown structural risks to neighboring properties. She cited no sources because there were none. She was manufacturing fear. I responded with a letter of my own, which Priya helped me draft. We attached the inspector's unfounded determination, the original county permit, the CAL FIRE defensible space guidelines referencing exactly this type of system, and a 1-page statement from Tom Cafferty describing his professional assessment. We mailed it to all 47 households. Sandra's response, delivered through Brenda Kowalski, was that I was being aggressive. Phil Okafor called me that evening. He said he'd been on the Sycamore Pines board for 4 years and had never seen Sandra pursue anything with this level of persistence. He said she'd been making calls to board members late at night, pressuring them. He also said something that lodged in my mind like a splinter. "Daniel, has she ever asked you about buying your property?" I told him no. He said, "Give it time." Phil's question sent me down a rabbit hole. I spent 2 evenings pulling public records, Sandra's LLC filings, Sycamore Pines property transfer records, any connection to a developer. What I found was thin but interesting. Craig Witowski, a developer I'd never heard of, had purchased 2 properties on the far end of the ridge in the past 18 months. Both sales had been brokered by Sandra's former real estate partner, a woman named Faye Dunlap. I shared what I'd found with Priya and with Tom. Priya said it was suggestive but not actionable without more. Tom said, "So she's trying to build something and your equipment is in the way of the listing photos." I said I thought it might be more than that. Tom looked at me for a moment and said, "Whatever it is, don't let her get the equipment down. That's the whole game." September arrived with the smoke columns that had become an annual ritual in our part of California. The Clearwater fire was burning 40 miles northeast, and the air quality index hit 180 for 3 consecutive days. I wore an N95 to walk to the mailbox. Carol ordered groceries delivered. Sandra, I noticed, had a new air purification system installed on her porch. A sleek stainless steel unit that probably cost $4,000. At the September board meeting, Sandra introduced a new agenda item, a formal safety audit of all exterior equipment in the community, to be conducted by a vendor she had selected, a property management consulting firm called Pacific Standards Group. She presented this as a routine matter of HOA due diligence. Phil Okafor asked who Pacific Standards Group was. Sandra said they were a reputable firm. Phil asked for their licensing credentials. Sandra said she'd follow up. She never followed up, but the audit was approved 4-1 with only Phil voting against. Luz Martinez had been pressured enough at this point that she'd switched her alignment. I watched the vote from the back of the room and felt something shift. Not panic, but a cold recognition that Sandra was constructing something, step by step, and I needed to understand its architecture before she finished building it. Pacific Standards Group turned out to be a real company, though barely. It was 18 months old, had 2 employees listed on LinkedIn, and its website had been created 4 months earlier. What I eventually traced, through a business license lookup Priya ran, was that one of its principals, a man named Derek Osman, had previously worked at a property management company that had listed 2 of Craig Witowski's developments. I brought this to Priya. She spent 2 days confirming what I'd found and then told me it was still not enough for a legal claim, but it was enough to present at a board meeting. She drafted a disclosure request, asking Sandra to formally disclose any financial relationships between the HOA Pacific Standards Group or any connected parties. Sandra's attorney responded that the request was outside the scope of standard HOA governance. The Pacific Standards Group audit was scheduled for mid-October. I was told I would receive a notice of inspection for my property 72 hours in advance. The notice arrived with 48 hours notice. When I pointed this out in writing to Sandra, citing the HOA rules, she responded that the timing had been an administrative oversight and that she hoped I would extend good faith. I did not extend good faith. I documented the procedural violation. Derek Osman showed up on inspection day with a clipboard and a camera. He was polite, maybe 35, and he had the look of someone who had been briefed extensively before arriving. He photographed the fence line equipment from 6 angles. He asked me no questions about function or permit status. He measured the sensor mounts with a tape measure. He spent 11 minutes on my property and 45 on Sandra's, where I presume the inspection involved a great deal of standing around drinking coffee. The Pacific Standards Group report arrived 3 weeks later, delivered by certified mail on a Friday afternoon. It was 12 pages. My system appeared on page 3, flagged as a non-conforming structure requiring remediation. The report cited the height of the sensor mounts, measured incorrectly at 14 inches, and classified the fence line equipment as a visual disruption inconsistent with community aesthetic standards. There was no mention of the county permit. There was no mention of fire safety function. I read the report twice, then called Priya, then called Tom, then opened a beer and sat on my back porch watching the sky turn orange over the national forest and understanding, with absolute clarity, that Sandra Hollis was coming for my system and she had spent the better part of 8 months building the paperwork foundation to do it legally. What I didn't yet know was how far she was actually willing to go. The HOA board convened a special session in November to review the Pacific Standards Group report. Sandra had sent individual emails to all 47 households summarizing the findings. Her summary, not the actual report. Her version described my system as flagged for multiple violations and recommended prompt remediation to protect community standards and property values. She sent this before the meeting had even taken place. I arrived at the November meeting with Priya at my side and a 3-ring binder containing every document relevant to the past 8 months. Permits, inspection records, CAL FIRE citations, the attorney correspondence, the procedural violations I'd cataloged, and a printed copy of the Pacific Standards Group principal's professional history, including his connection to Witowski's developments. Sandra looked at the binder and her expression didn't change at all. That bothered me more than if she'd reacted. Priya presented our case methodically, starting with the permit documentation, moving to the inspection certifications, and ending with the conflict of interest question regarding Pacific Standards Group. She was precise and calm and professional. Sandra waited until Priya finished and then said, "I appreciate the presentation, but this board has a responsibility to enforce community standards, regardless of outside permitting." She said it like a person who had rehearsed it many times. Ron Feltner made a motion to formally adopt the Pacific Standards Group report as an official HOA finding and to issue me a remediation order requiring removal of the non-conforming structures within 30 days. Sandra seconded immediately. Phil Okafor asked whether the board intended to seek a second opinion from a fire safety professional before voting on equipment with a documented fire suppression function. Sandra said that was outside the scope of this review. The vote was 3-2. Sandra, Ron, and Brenda against Phil and, to my genuine surprise, Luz Martinez, who had found her footing again at the worst possible moment. The remediation order passed. I had 30 days to remove my system or face daily fines of $150 and potential legal action. Priya squeezed my arm as we walked out. "We appeal," she said. "We appeal everything." We filed an appeal with the HOA's internal dispute resolution process the following morning. California Civil Code Section 5900 requires HOAs to offer alternative dispute resolution before pursuing enforcement. Sandra knew this, and her attorney had clearly prepared for it, because they responded within 24 hours accepting the ADR demand and scheduling a session for 3 weeks out. It was the most efficient response I'd gotten from Sandra's camp in months. That efficiency worried me. The ADR session was held at a neutral mediator's office in downtown Riverside. The mediator was a retired judge named Harold Fisk, who had the energy of a man who had witnessed every possible category of human disagreement and was no longer surprised by any of it. Sandra arrived with her attorney and Brenda Kowalski. I arrived with Priya and Tom Cafferty, who was there as a professional witness willing to testify to the system's function. Judge Fisk gave each side 90 minutes. Sandra's attorney argued that the HOA had the authority under the CC and RS to regulate exterior structures, and that the Pacific Standards Group report constituted sufficient expert finding. Priya argued that the county permit superseded HOA aesthetic authority in matters of permitted safety equipment, cited 2 California appellate cases, and noted the conflict of interest issues with Pacific Standards Group. Tom spoke for 12 minutes about wildfire behavior and what my system could do. Judge Fisk took notes throughout. The ADR session produced no resolution. Sandra's side declined every compromise proposal, offering to partially screen the equipment, to provide additional documentation, to allow a visit from an actual CAL FIRE official. Sandra's attorney said the HOA's position was that aesthetic compliance is non-negotiable. Judge Fisk, wrapping up, looked at Sandra over his reading glasses and said, "You do understand, Ms. Hollis, that this equipment has a documented fire safety function?" Sandra said, "I understand there's a permit." She said it like the permit was the problem. Priya filed a civil complaint in Riverside County Superior Court 2 days after ADR failed. We were suing to enjoin the HOA from enforcing the remediation order pending a full trial. The case was assigned to Judge Maria Castillo, who set an expedited hearing for 6 weeks out given the wildfire season context. I spent the next 6 weeks doing 3 things: preparing for the hearing, continuing to run my system, and watching Sandra. What Sandra did in those 6 weeks was remarkable in its pettiness and its precision. She had the HOA landscaping crew, a service she controlled the contract for, schedule a maintenance visit that brought a truck and trailer to within 50 feet of my fence line. Nothing happened that day, but I photographed the truck, the crew, and the timestamp. I was building my own file now. She also persuaded Garrett Phelps to install a 6-foot wooden privacy fence along our shared property line, which happened to partially obstruct the sight line from my primary heat sensors to the treeline. The fence was technically within code and within Garrett's rights. It reduced my sensor coverage by about 15%. I repositioned 2 sensors to compensate. I documented the change and its cause. Phil Okafor called me in December to tell me that Sandra had raised the topic of my legal costs at the last closed board session. Specifically, whether the HOA could assess those costs to me as the party that had initiated litigation. It was backwards. We'd been forced into court by the remediation order. But Sandra had apparently framed it as me suing the community. Phil said 2 board members had seemed receptive to the framing. Tom came by that same week with something he'd found on the county assessor's website. Craig Witowski had filed a preliminary development application for a project on Ridgeback Ridge, 6 properties. Proposed conversion to short-term rental units under a new regulatory framework the county was considering. The application listed a project coordinator. The project coordinator was Faye Dunlap, Sandra's former real estate partner. Tom printed the page and handed it to me without a word. I gave the Witowski application to Priya immediately. She added it to our evidentiary file and noted that while it didn't prove Sandra had a direct financial interest in removing my equipment, it established a plausible motive for why the HOA was pursuing a remediation order against a permitted fire safety system with unusual persistence. She used the word unusual in the way attorneys use words they've chosen carefully. The court hearing was in late January. Judge Castillo was efficient and attentive. She'd clearly read the briefs. She asked Sandra's attorney 3 pointed questions about the legal basis for overriding a county-issued permit with an HOA aesthetic finding, and each answer was less satisfying than the last. Sandra sat at the table in a dark blazer and looked composed, but I noticed she was clicking a pen under the table the whole time. Judge Castillo issued a preliminary injunction the following week. The HOA was enjoined from enforcing the remediation order pending trial. My system stayed. I got the ruling via text from Priya. 5 words. Injunction granted. System is safe. I sat in my truck in the parking lot of a Home Depot and called Carol. She was quiet for a moment and then said, "Good. Now can we have a normal spring?" We could not have a normal spring. Sandra's response to the injunction was to call an emergency HOA meeting, which she was entitled to do under the bylaws. The stated purpose was to discuss legal strategy regarding the Marsh litigation. What actually happened was that Sandra used the meeting to conduct what amounted to a community trial, presenting a prepared narrative in which I was characterized as a homeowner who was above the rules and burdening the community with legal costs. I wasn't allowed to attend the emergency meeting. Sandra had cited a provision allowing closed sessions for legal matters in litigation. Phil attended and called me afterward. He said Sandra had shown a slide with a running total of HOA legal costs attributable to the Marsh dispute, $34,000. He said she'd let that number sit on the screen for 30 seconds without speaking. He said 3 people had started crying. One of them was Brenda Kowalski, who had voted to create those costs. Tom pointed out something I'd missed. Sandra had never, in any meeting, any letter, or any legal filing, mentioned the possibility that the HOA might bear legal costs if it lost the case. She'd presented only the current cost, not the potential cost of continuing. I asked Priya about this. She said it was a classic HOA pressure tactic. She also said, if they lose at trial, they're looking at paying your attorney fees too. I asked her to write that down somewhere Sandra's attorney would see it. February brought the first real wind event of the year. A Santa Ana pattern that dropped humidity to single digits across the ridge and pushed sustained winds of 35 miles per hour from the northeast for 4 days. The National Forest Service closed the trails in the area. My sensors flagged elevated risk automatically, which triggered an alert to my phone. I went home, checked the system, ran a pressure test. Everything was operational. On the 3rd day of the wind event, a neighbor 2 streets over from me had a backyard fire pit that caught and briefly spread to a section of dry brush before the fire department contained it. It was small, half an acre, no structures. But the smoke was visible from my back porch and my sensors had registered the ambient temperature spike immediately. I watched the smoke and thought about what would have happened if that fire had reached the tree line during the peak wind. Sandra sent a HOA newsletter that same week. It included a section on fire safety awareness, 3 paragraphs citing CAL FIRE's official community guidance, encouraging homeowners to maintain defensible space and clear dry brush. It made no mention of my system. It made no mention of the ongoing litigation. It read like a document written by someone who wanted credit for fire safety consciousness without acknowledging the person on the ridge who'd actually built fire safety infrastructure. I started keeping a detailed log in February. Every system reading, every weather event, every HOA communication, every court filing. I logged conversations with neighbors. I logged the date Sandra's landscaping crew appeared on our street. I logged the date Garrett's fence was extended by another 4 feet without a permit I could find on file. I was becoming the kind of meticulous, documentation-obsessed person I'd always made fun of, and I was completely at peace with it. March brought the pretrial conference. Judge Castillo pushed for settlement. Sandra's attorney proposed that I voluntarily relocate my system to a less visible location. Specifically, the east side of the property, away from the primary fire approach corridor. I told Priya that relocating the system away from the west-facing tree-line interface would reduce its effectiveness by approximately 60%. Priya told the court. The judge noted it. Settlement talks ended. What I didn't realize until Phil told me in April was that Sandra had been quietly negotiating with Craig Witowski the entire time the litigation was pending. Phil had overheard a phone call. Sandra had been standing near the open window of the clubhouse and caught enough fragments to understand that Witowski was interested in 2 specific properties that formed the visual gateway to the ridge. One of them was my neighbor Tom's house. The other was mine. I told Tom immediately. He was quiet for a long time. Then he said, "She wants to buy us out." I said I thought that was part of it, but I also thought there was something more specific about my property, about the equipment, about whatever the system represented to her plans. Tom said, "Your tank is on the west hillside. If Witowski builds anything there, that ground is his." I hadn't thought about the land. I started thinking about the land. The trial date was set for mid-June. Priya told me our case was strong. The permit documentation was solid. The ADR record showed Sandra's side refusing every reasonable accommodation, and the Witowski connection, while circumstantial, established the appearance of a conflict of interest that a jury would find troubling. She said she liked our chances. She also said, "Something about this case bothers me, Daniel. Sandra doesn't lose things. Whatever she's planning, she hasn't played it yet." In April, Sandra played it. She contacted every major homeowner's insurance carrier that served Sycamore Pines and reported, falsely, that I had an uninspected underground water storage system on my property. 2 carriers sent letters to their policyholders in the community suggesting they review their coverage in light of potential water table disruption. One carrier sent me a letter directly, flagging my policy for review. The insurance gambit was the most dangerous thing Sandra had done. My coverage was with Pacific Coast Mutual, and when their underwriting department received Sandra's complaint, they opened a formal inspection request. I had 2 weeks to respond with documentation or risk a policy suspension. I spent those 2 weeks in a focused panic, gathering every inspection record, the county permit, the installer certifications for the tank material and liner. Priya fired off a letter to Pacific Coast Mutual's legal department documenting the origin of the complaint. Pacific Coast Mutual's inspector came out in early May. He was thorough, more thorough than the county inspector, actually, and spent 2 hours on the property. At the end, he told me the system was better documented than most permitted commercial installations he'd reviewed. My policy was confirmed with no changes. 2 weeks later, Pacific Coast Mutual's legal team sent a letter to Sandra through her attorney noting that filing a false complaint with an insurance carrier could constitute tortious interference. Sandra's attorney responded that she had acted in good faith. The insurance episode changed something for me. Up until then, I'd been fighting defensively. responding to each of Sandra's moves with documentation and legal process. After the insurance gambit, I understood that Sandra was willing to cause me real financial harm, not just administrative inconvenience. She tried to kill my insurance coverage in a wildfire zone. That wasn't HOA overreach. That was something else. I had a conversation with Priya in May that I think back on often. I asked her whether, given everything, there was any scenario in which Sandra would stop short of the trial. Priya was quiet for a moment. She said, "Sandra has invested too much to back down. She needs either a win or a way to make the loss look like someone else's fault." I asked what the second option looked like in practice. Priya said she didn't know yet. That was the most unsettling thing she'd ever said to me. May was also when I made a decision I told no one about. Not Priya, not Tom, not Carol. The injunction protected my existing system from removal, but the injunction only covered the specific components listed in the remediation order. What I decided to do, quietly and over the course of 3 weekends, was install a secondary backup array along the roofline, concealed within the existing gutter system, that Sandra had never photographed and that didn't appear in any HOA filing. It was fully permitted. I pulled the permit under a gutter system enhancement classification that was accurate enough to be true. If Sandra ever got the primary system down, there would be a backup. I wasn't taking chances. June arrived. The trial was 2 weeks away. The Ridgeback Ridge area had already seen 3 red flag weather events before summer officially began. Cal Fire had prepositioned a Type 1 engine at the station 4 miles from our ridge for the first time in non-emergency conditions, a sign that the agency's risk modeling was flashing warnings. I mentioned this to Sandra's neighbor, a quiet retired professor named Arthur Lim, and he told me Sandra had been advising neighbors that the fire risk in Sycamore Pines is overstated by the media. Arthur shook his head as he said it. The week before trial, Sandra made an offer through her attorney. She proposed dropping the remediation order, contributing $15,000 toward my legal costs, and expunging the HOA violation record, in exchange for my agreeing to sell my property to a buyer of her choosing within 18 months at fair market value. It was the most explicit thing she'd ever done. I showed it to Priya. She looked at it for a long time. Then she looked at me. "She's been trying to buy this property since the beginning," she said. "This was never about the equipment." I said, "I know." I said, "I'm not selling." I rejected the settlement offer on a Thursday morning in June, 5 days before trial. Priya sent the formal rejection letter. I drove up to the ridge overlook that evening and sat on the hood of my truck watching the orange edge of the sky over the forest to the east. It was the kind of evening that looked beautiful and smelled like kindling. I'd made the right call. I was certain of it. The days before trial were quieter than I expected. Sandra didn't make any new moves. Her attorney sent some last-minute discovery requests that Priya described as desperate. The HOA board held no emergency meetings. Garrett Phelps waved at me from his driveway for the first time in 6 months. I waved back. Small things. Carol and I had dinner on the back porch Friday evening. Her pasta e fagioli, a bottle of the Paso Robles red we'd been saving for something. She asked if I was scared. I said I was tired. She said those were the same things sometimes. We sat out there until the coyotes started up in the hills and went inside. It was the most peaceful evening we'd had in a year. Tom came by Saturday morning with coffee and pastries from the bakery on Route 9. We sat at the kitchen table and he told me stories about the fires he'd worked in San Bernardino, nights when the wind shifted and the math changed in 30 seconds and the only thing standing between a structure and a flame front was whatever someone had thought to build before that moment. He wasn't trying to scare me. He was reminding me why any of this mattered. I ran a full system check on Saturday afternoon. Primary array, pressure nominal, sensors calibrated, pump response time 4.2 seconds. Secondary backup array, the gutter line installation Sandra knew nothing about, tested manually from the rooftop access panel. Both systems operational. I documented everything, photographed the gauges, logged the readings. I was ready, not for the trial, for the fire season. Sunday was genuinely normal. Marcus called from Portland. He's in software development now, which occasionally makes me wonder where I went wrong, and we talked for 45 minutes about nothing important. Carol's book club met in the living room, and I hid in the garage with a podcast and reorganized my tool bench. The HOA felt very far away. Phil Okafor texted me Sunday evening. He'd been at a neighborhood gathering that afternoon, nothing formal, just people in someone's backyard, and he said Sandra had been notably subdued. No HOA talk, no mention of the trial. She'd spent most of the afternoon talking with Brenda about a vacation to Arizona. Phil said, either she's accepted she's going to lose, or she's saving something. I wrote back, it's the second one. He sent back a thumbs up emoji and then nothing else. Monday morning, trial minus 2 days, I drove to Priya's office for a final prep session. We went through the witness order, Tom first, then the county building inspector who'd cleared my system after Sandra's complaint, then a Cal Fire Battalion chief named Hernandez who'd agreed to testify about wildfire behavior and the function of rooftop suppression systems. Then me. Priya said, you're the anchor witness. You just tell the story in order, like you're explaining it to someone reasonable. I said, what if the jury isn't reasonable? She said, that's what I'm for. Tuesday was the last quiet day. I worked in the yard, cleared some brush along the south fence line, the irony of that not lost on me, and checked my sensor array one final time. The marine layer was in, sky the color of an old bruise, and the air smelled faintly of charred wood from a small fire 2 counties east. I stood by the west fence and looked out at the chaparral sloping down toward the forest boundary. The October dry grass was silver tan and continuous. Everything was waiting. I got an email at 9:47 that Tuesday night. It was from an address I didn't recognize. No subject line. One sentence. Check your back fence utility panel before you go to court. I stared at it for a long time. Then I put on my shoes, got my flashlight, and went outside. The back fence utility panel is a gray metal box, 12 by 12 inches, mounted at the midpoint of the west fence. It houses the primary electrical connections for the sensor array, the relay switches, the timer controls, and the pressure regulator interface. I'd installed it myself and wired it myself, and I knew exactly what it was supposed to look like when I opened it. What I found when I opened the panel at 10 p.m. on a Tuesday night was that the main circuit relay had been switched from auto to bypass. In bypass mode, the sensor still read, the app still showed green, but the relay to the pump would never fire. The system would appear fully operational on every diagnostic I ran from my phone. The sprinklers would never actually activate. Someone had been in my panel. Someone who knew exactly what that switch did and exactly how to make the sabotage invisible to a remote diagnostic. My hands were steady when I switched the relay back to auto. My hands were steady the whole way inside. I sat down at the kitchen table and felt the kitchen around me with a kind of heightened clarity I associate with moments when something serious has just happened. I called Tom at 10:15. He answered on the second ring. I described what I'd found. There was silence on his end for about 5 seconds, and then he said, "That's criminal tampering with a fire suppression system." He said it quietly, precisely, like he was reading from a statute. I said, "Who would know what that switch does?" He said, "Someone who's looked at your installation plans, or someone who had help from someone who has." I called Priya at 10:30. I described what I'd found. She asked me to take photographs immediately and not touch anything else in the panel, and to send her the photos along with the anonymous email. She said, "This is a criminal matter, Daniel. We're calling the sheriff's department tonight." I said, "What about court Thursday?" She said, "This changes what we do in court Thursday." Her voice was calm the way voices get calm when the situation has become serious enough to demand it. The Riverside County Sheriff's deputy who came out that night was named Reyes. He was in his late 30s, methodical, and he took the anonymous email and the panel tampering seriously. He photographed the panel, took possession of my phone for a forensic copy of the email, and walked the property line with a flashlight looking for signs of entry. He found a footprint in a soft patch of soil near the fence gate, just one partial, the tread of what he estimated was a men's size 10 or 11 boot. Deputy Reyes told me the tampering wouldn't be slam dunk to prosecute without more evidence of who'd done it, but that it was serious enough to open a criminal file. He also said something that landed hard. "Sir, you understand what would have happened if a fire had started while that relay was bypassed?" I said yes. He said, "Your system would have been useless." I said, "I know." He wrote in his notes for a while without looking up. I did not sleep. I sat at my desk until 3 a.m. with the relay bypass photo open on my laptop and the anonymous email next to it, and I thought about who had the information to know what that switch did. My installation plans were in the county permit file public record, accessible to anyone who filed a records request. Sandra's attorney had subpoenaed my system documentation 9 months ago for the litigation. They had the plans. By 4 a.m. I had a theory. Not proof, a theory. I'd been so focused on the legal fight that I hadn't been watching the physical space the way I should have. The Garrett Phelps fence extension. The landscaping crew truck parked near my gate 3 weeks ago. Someone had been watching my system, learning it, waiting for the right moment. 2 days before trial was the right moment. An act of sabotage that might have gone unnoticed, that would have left my system appearing operational while actually being useless, that might have discouraged me from making an issue of the trial's fire safety arguments because my system would, demonstrably, not have worked. I sent Priya a message at 6 a.m. with my theory laid out in bullet points. She responded at 7:15 with 4 words, "I'll be there at 8. She arrived with a paralegal and a forensic consultant she'd pulled in on an emergency basis. They spent 2 hours in my backyard, the panel, and the file boxes of documentation I'd accumulated over the past 18 months. The forensic consultant, a compact, serious woman named Dr. Andrea Wolf, who apparently specialized in digital evidence in civil litigation, focused on the anonymous email. Within 90 minutes she told us it had been sent from a burner email account created that evening, routed through a VPN, but that the VPN provider had a policy of cooperating with law enforcement subpoenas. She said a subpoena could potentially identify the sender. Potentially. Priya filed an emergency motion with Judge Castillo that morning, requesting a continuance of the trial and a contempt hearing related to what she characterized as willful interference with evidence and potential obstruction of justice related to pending litigation. She attached photographs of the panel, the deputy's incident report number, and Dr. Wolf's preliminary findings. Sandra's attorney filed a response the same afternoon calling the motion inflammatory and unsupported. Judge Castillo granted a 1-week continuance and set a contempt hearing for the following Friday. She also issued a SUA spont order requiring all parties to preserve any digital communications related to the Marsh HOA dispute for the preceding 30 days. Sandra's attorney's response to that order came back within an hour, faster than any response we'd previously received. The speed itself was telling. I went to the HOA board meeting that Wednesday evening, the regular monthly meeting, which happened to fall on the worst possible day for Sandra. She hadn't canceled it. I assumed canceling it would have looked like something. She sat at the head of the table in a cream-colored blazer and ran through the agenda with the precision of someone navigating a minefield by memory. I sat in the back. Tom sat beside me. Phil Okafor sat 3 chairs down from Sandra and watched her the way a person watches a fuse that's been lit. Sandra did not mention the criminal complaint. She did not mention the continuance. She did not mention the contempt hearing. She ran through the HOA budget, a landscaping contract renewal, a discussion about holiday decorations. When she reached the end of the agenda and called for other business, I raised my hand. She recognized me with an expression of precise neutrality. I said, "I'd like to note for the record that my fire suppression system was tampered with this week. The sheriff's department has opened a criminal investigation." The room was very quiet. Sandra said, "I'm not aware of any formal findings on that matter." I said, "The investigation is ongoing." She moved to adjourn. Brenda Kowalski caught me in the parking lot after the meeting. She was agitated in a way I hadn't seen before. Her usual composure replaced by something that looked like genuine fear. She said, "Daniel, I need you to know I had nothing to do with whatever happened to your system." I said I noted that. She said, "Sandra said it was necessary. She didn't tell me what it was. I should have asked." Then she got in her car and left. I stood in the parking lot for a moment. Then I called Priya. Priya's response to what Brenda said was immediate. "That's a witness. We need her statement before she changes her mind." She called Brenda directly that evening. Brenda, to her credit, agreed to speak with Priya the next morning. What Brenda told Priya, and what would later appear in a sworn declaration, was that Sandra had said, 2 days before the panel tampering, that she had found a way to demonstrate that Marcia's system doesn't actually work. Brenda said she'd assumed Sandra meant something legal. The forensic trail was developing in parallel. Dr. Wolf had identified that the VPN used to send the anonymous email was a service called NordGhost that maintained IP logs for 60 days. The sheriff's department had served an emergency subpoena to NordGhost's U.S. legal representative. The response would take up to 72 hours. I drove home from Priya's office that Thursday knowing that someone was going to be identified by Monday at the latest. What I didn't expect was that the identification would come from a different direction entirely. Tom called me Friday morning with information he'd gotten from a former colleague in the San Bernardino Fire Department. Not anything official, just a conversation. Someone matching Derek Osmond's description, the Pacific Standards Group principal who'd done the audit of my property, had been spotted in Sycamore Pines on the Tuesday evening before the panel was tampered with. He'd been parked on Ridgeback Lane for approximately 40 minutes. A neighbor had noticed because the car was unfamiliar and they'd noted the license plate. The license plate came back to a rental car. The rental car had been rented by Derek Osmond's business address. Tom handed me the printout like he was handing me a piece of a puzzle he'd already assembled. "She used her audit guy," he said. "She's been using him from the start." I thought about Derek Osmond with his clipboard and his camera, spending 11 minutes on my property but photographing the fence line from 6 angles. He'd been taking notes. I gave Tom's information to Priya. She gave it to Deputy Reyes. Reyes ran the rental car through the DMV and confirmed the registration. By Friday afternoon, Derek Osmond had a deputy from the sheriff's department at his door in Riverside. I don't know what was said at that door. I know that by Friday evening, Derek Osmond had called a criminal defense attorney. I know this because his attorney sent a letter to Sandra's attorney that evening. Priya found out about it by Saturday. The contempt hearing was Friday. Judge Castillo had reviewed our filings and the sheriff's incident report overnight. She opened the hearing by addressing Sandra's attorney directly. "Counsel, I want you to understand that this court takes allegations of tampering with the permitted safety system very seriously, and that the timeline of events your client's apparent consultant is now connected to is going to require a full explanation." Sandra's attorney said his client denied all involvement. The judge said, "That's noted." At the contempt hearing, Priya presented the timeline. The anonymous email, the panel tampering, Brenda's declaration about Sandra's comment, Derek Osmond's presence in the neighborhood, the rental car. She presented it without drama, point by point, letting the documents speak. Sandra sat at the defense table in the same cream blazer and stared at a point on the wall approximately 2 feet above Judge Castillo's head. Sandra's attorney's defense was essentially that everything was circumstantial. Derek Osmond's presence in the neighborhood was not illegal. Brenda's declaration was a mischaracterization of casual conversation, and the email origin could not yet be definitively linked to anyone. Judge Castillo acknowledged the evidentiary limitations. She did not grant contempt on the criminal standard. What she did do was issue a formal admonishment to Sandra and the HOA for conduct inconsistent with good faith litigation, and she moved the trial date up 2 weeks. I came home from the contempt hearing and sat in my truck in the driveway for a long time. Carol came out eventually and knocked on the window. I rolled it down. She said, "How'd it go?" I said, "She got away with it today." Carol said, "Did you expect her not to?" I thought about that. I said, "No." Carol said, "Come inside. The system's still up." I went inside. The Nordghost subpoena came back the following Monday. Dr. Wolf reviewed it and told Priya that the IP address behind the VPN had resolved to a residential broadband account in Sycamore Pines. The account was not registered to Sandra Hollis. It was registered to Ron Feltner. I sat with that information for a moment. Ron Feltner, who had always struck me as Sandra's most reluctant ally, the one who looked slightly uncomfortable delivering the first violation notice. Ron Feltner had been the one to send the email. We had Ron Feltner's IP address. We had Derek Osmond's rental car outside my house the same evening. We had Brenda's declaration about Sandra's comment. What we didn't have yet was the direct link between Sandra and Derek Osmond for the panel tampering specifically. What we needed was Derek Osmond to talk. His attorney, it turned out, was having conversations about exactly that. Priya got a call from Osmond's attorney on Tuesday. The attorney said his client was prepared to cooperate with ongoing investigations in exchange for consideration on any criminal charges. The sheriff's department wasn't our client and we couldn't make that deal. But we could, Priya explained to me, subpoena Osmond for the civil trial. And whatever he said on the stand under oath would be on the record. She scheduled the subpoena immediately. Meanwhile, the HOA dynamics were shifting visibly. Phil Okafor told me that 3 board members had stopped attending Sandra's informal pre-meeting calls, the Tuesday evening check-ins she used to coordinate votes before official meetings. Luz Martinez had reportedly told Sandra she was concerned about the direction things were going. Even Ron Feltner had been largely silent at the last board session. The machine was developing friction. Sandra's response to the friction was to tighten her grip. She sent a memo to all board members. Phil shared it with me, reminding them of their fiduciary duty to support the HOA's legal position and warning that any public statements inconsistent with the board's official stance could expose individual members to personal liability. It was a threat dressed as legal guidance. Phil called it the most Sandra-like thing I'd ever received in writing. He kept it. He was going to give it to Priya. The California Wildfire Outlook for the coming summer was released by the state's fire agency in June. The long-range forecast called for above-normal fire potential across Southern California from August through October, driven by drought conditions and projected La Nina patterns. Cal Fire was expanding its prepositioning program and requesting additional air resources. The governor held a press conference. I watched it on my laptop while sitting next to a functioning suppression system that someone had tried to disable 8 days ago. A week before the rescheduled trial, Derek Osmond reached a cooperation agreement with the Riverside County DA's office. In exchange for a misdemeanor charge and community service on the tampering count, he would provide a full statement. The statement, shared with Priya through formal channels the following day, confirmed what we'd suspected. Sandra had hired him not just for the audit, but for a specific project she described as verifying the operational status of my system. She had given him a copy of my installation plans, obtained through the litigation subpoena, and told him what the relay switch did. He had accessed my property through the rear gate, which was on a combination lock whose code Sandra had learned from the landscaping service. He had been paid $3,000 in cash. I read Osman's statement in Priya's conference room, seated at a long table with the afternoon sun coming through the windows, and felt a kind of cold, absolute clarity. Sandra had used litigation discovery to obtain my system plans. She had hired a man to physically sabotage my fire suppression equipment. She had done this 2 days before a trial about whether that equipment should be removed. She had done all of this knowing that we were entering fire season with a red flag forecast on the books. The $3,000 in cash was almost the worst detail. It was so deliberate, so calculated. It was the detail that made it impossible to pretend any of this had been a mistake. Priya filed an amended complaint that afternoon adding Sandra Hollis personally, not just the HOA, as a defendant, on charges of intentional interference with a permitted safety system, tortious interference with contract, and civil conspiracy. She also notified the Riverside County DA's office of the full scope of the conduct. The DA's office, which had been tracking the Osman investigation, elevated its review to include Sandra as a potential subject. I got a call from Arthur Lim, the retired professor next door to Sandra, that evening. He said Sandra had been out of her house very little in the past few days. Her car was in the garage. Her lights were on but her usual patterns: morning walk, afternoon mail collection, evening conversation on the porch, had stopped. Arthur said, "She looks scared, Daniel." I said I thought she had reason to be. Arthur said, "I always thought she was just a bully. I didn't know she was capable of this." I said I wasn't sure she'd understood what she was capable of either, until she did it. The trial was now 12 days out. Priya and I met every afternoon that week, sometimes joined by Tom and sometimes by Dr. Wolf. The case had expanded significantly. What had started as an HOA aesthetic dispute was now a civil action with criminal referral implications involving system tampering, fraud, conspiracy, and a real estate development motive we intended to lay out in full at trial. Priya said, "I want to tell the whole story, not just the violation notice. Everything in order from the first meeting to the panel." I said, "Good. Let's tell the whole story." Garrett Phelps showed up at my door on a Wednesday evening, uncomfortable in the way people are when they need to say something they should have said months ago. He told me Sandra had approached him in January with a proposition: add the fence extension along our shared property line, in exchange for Sandra's help fast-tracking a variance he needed for a backyard structure. He'd done it. He was sorry. He said, "I didn't know it would mess with your system. I didn't know what she was building." I thanked him for telling me. I called Priya. We added it to the file. The week before trial, the weather shifted. The marine layer that had been cooling the coast broke, and a ridge of high pressure built over Southern California that meteorologists were describing as anomalous for June. Temperatures in the mid-90s, relative humidity in the teens, and offshore flow that was drying the chaparral faster than any model had predicted for this early in the season. Cal Fire moved to staffing level 2. The state's fire weather watch covered most of our county. I checked my system every morning that week. Primary array, operational. Backup gutter line array, operational. Tank pressure, 94%. I logged it every day at 6 a.m. before Carol was up. She knew I was doing it. She didn't say anything. She started making coffee earlier so it would be ready when I came back inside. For days before trial, Sandra's attorney filed a motion for continuance citing evolving discovery matters requiring additional time. It was rejected by Judge Castillo in less than 24 hours. The judge's order was 3 sentences. The last sentence was, This matter has been pending long enough. I read it in the parking lot of a grocery store and said, out loud to no one, yes it has. 3 days before trial, Phil Okafor resigned from the HOA board. His resignation letter, which he copied me on, which I'm fairly certain he wasn't required to do, stated that he could no longer in good conscience participate in a board whose leadership had pursued a campaign against a homeowner's fire safety infrastructure using methods I now understand to have included physical tampering with permitted equipment. It was a clean, precise, courageous letter. Phil doesn't do things by half measures. He never did. Luz Martinez resigned the following day. Her letter was shorter. 2 paragraphs, no details, citing irreconcilable differences with current board leadership. She sent me a text that same evening. I'm sorry I didn't do this sooner. Good luck Thursday. I wrote back a simple thank you. 2 board resignations in 2 days. The HOA was in structural free fall and the trial hadn't started yet. Ron Feltner did not resign. He went quiet. His IP address had been provided to the DA's office. He had, as far as I knew, not yet been contacted directly by investigators. He was probably waiting to see what happened at trial. I understood the impulse. I didn't respect it. Sandra appeared at the HOA clubhouse the Sunday before trial for what she'd scheduled as an emergency community meeting. Phil and Luz weren't there, obviously. Brenda sat at the far end of the table and said almost nothing. The only people in the room were the homeowners Sandra had most consistently cultivated, 7 or 8 households who'd been reliably in her corner. She told them the lawsuit was being weaponized by a homeowner who wanted to circumvent community standards. She said she remained confident in the legal outcome. She said the HOA's attorney had advised that the tampering allegations would not survive scrutiny. She said all of this with a composure I found at this stage genuinely impressive. Whatever she was feeling, she was not letting it show in that room. I found out about the Sunday meeting from 3 different people who attended and felt uncomfortable enough about it to text me afterward. One of them, Denise Farrow, who'd asked Sandra about fire safety expertise at the original community meeting 2 years ago, said Sandra had shown a slide comparing the cost of continuing the litigation versus settling. The settlement column showed $0 if I accepted a modified agreement. The modified agreement she described was the same property sale proposal she'd made before, dressed up with different numbers. Denise said, I asked her who the buyer was. She said it was a private party. I asked her if she had a financial relationship with the buyer. She said that was not relevant to this meeting. Denise had walked out. Monday before trial. I was reviewing documents with Priya when my phone showed an alert from the Cal Fire monitoring app I'd had for 3 years. Red flag warning issued for Riverside County mountains and inland valleys. Elevated fire weather conditions possible Tuesday through Thursday. I showed the alert to Priya. She looked at it for a moment. She said, Daniel, when does the wind typically peak during a red flag event? I said, usually late afternoon, 2nd or 3rd day. She said, trial starts at 9 a.m. Thursday. I said, I know. I went home Monday evening and ran a full system diagnostic. Primary array, 100%. Backup array, 100%. Tank, 96%. I sat on the back porch and looked at the western hillside for a long time. The grass was the color of pale straw. The chaparral on the slope below the fence line had the specific dry glitter it gets when the humidity drops below 15%. A look I'd learned to recognize as the look of things that would burn quickly if given the chance. I went inside and checked the weather forecast one more time. Low humidity through Thursday. Wind from the northeast, 15 to 25 miles per hour, gusting to 35. Tuesday was prep day. Tom came over and we walked the whole system one more time. He checked the sensor calibration while I ran through the pressure curves on the pump controller. Everything was where it should be. The gutter line backup array was invisible from the street. Sandra didn't know it existed, which meant that even if she'd wanted to send Osman back, she'd have no target. That thought gave me something close to satisfaction. I got a call from a number I didn't recognize Tuesday afternoon. The voice was male, quiet, and when I asked who was calling, he said, "Someone who works for Craig Witowski." I said nothing. He said, "Mr. Witowski wants you to know he had no knowledge of what Ms. Hollis did. He's prepared to provide a statement to that effect." I said I'd have my attorney reach out. He said that would be fine. Then he hung up. I called Priya. She said, "Witowski is cutting her loose." I said, "Everyone is cutting her loose." Priya said, "That's what happens when the ship starts sinking." Wednesday was the last day before trial. I spent the morning reviewing my own testimony with Priya, the sequence of events, what to say when, how to handle cross-examination. Her advice was simple. Tell the truth, in order, calmly. The story is good enough. Don't editorialize. I told her I'd try not to. She said, "You'll editorialize. Just do it quietly." She knows me. Carol made dinner Wednesday night and we ate without talking much. After dinner, she asked me how I felt. I said I felt like the system was going to work. Not just the court case, the actual system. Like whatever happened in court, the thing I'd built was going to do what it was designed to do. She said, "That's the first time in a year you've said that without caveats." I said I'd been thinking about it a lot. She said, "Good. Now sleep." I did sleep, but at 4:30 a.m. Thursday morning my phone lit up with a text from Tom. Wind picked up. Checking the news. RFW in effect. I was already awake. I checked the CAL FIRE app. The red flag warning had been upgraded to an extreme fire weather warning at 4 a.m. I went to the back porch. The air was moving fast from the northeast, warm and bone-dry, and the oak tree in the yard was bending slightly. The coyotes were quiet, which was something they did when the weather changed. I checked the system at 5 a.m. Everything operational. Then I got dressed, made coffee, and prepared for court. Carol drove me so I wouldn't have to worry about parking. I had my documents in a briefcase and my phone showing the system status app on a background screen. We pulled out of the driveway at 7:45. The sky to the northeast had an amber cast that Tom would have recognized immediately. I recognized it too. We arrived at the Riverside County Courthouse at 8:30. Priya was already in the lobby with her paralegal and a banker's box of exhibits. She looked sharp and focused. She handed me a coffee and said, "How's the system?" I said, "Green across the board." She said, "Good. Let's go win this thing." We walked to the elevator. I checked the CAL FIRE app one more time. No active fires in Riverside County. Not yet. Sandra arrived at 8:55 with her attorney and, notably, alone. No Ron Feltner. No Brenda Kowalski. Her husband, whom I'd seen at HOA events maybe twice in 3 years, was not with her. She walked through the lobby in a dark blue blazer, looking straight ahead. She did not look at me. I looked at her with the attention of someone who had spent 18 months studying her methods, and what I saw in her posture, for the first time since this started, was something I hadn't seen before. Not fear exactly. Calculation gone quiet, like a machine idling. The courtroom was smaller than I'd expected. Judge Castillo entered at 9 a.m. on the dot. The jury, 8 people, selected over 2 days the prior week, was seated. Priya had told me what she thought of the jury. 3 of them are homeowners in HOA communities. 2 have lived through a significant fire event. 1 is a retired county inspector. I like us. I liked us too. Opening statements. Sandra's attorney went first. He presented a version of events in which the HOA had consistently acted within its authority to enforce community standards. The litigation had been initiated by a homeowner unwilling to accept reasonable governance, and the allegations of tampering were unproven and speculative. He spoke for 22 minutes. He was polished. He was good. He was also, by my count, wrong about 14 specific factual matters. Priya's opening was 38 minutes. She started with one sentence. This case is about what happens when someone in authority decides that a neighbor's fire safety matters less than her real estate plans. Then she told the story, all of it in order: the permit, the violation notice, the manufactured conflict, the insurance gambit, the rigged audit, the settlement offer to buy my property, and, at the end, the panel tampering 2 days before trial, 2 days before fire season, with the red flag warning now active outside these windows. She said it quietly, and it landed like a stone in still water. Judge Castillo called a brief recess at 10:30. I stepped out into the hallway and checked my phone. The Cal Fire app showed a new incident: brush fire, Ridgeback Road, Riverside County. Reported 10:17 a.m. 0 acres contained. My stomach dropped. I called Tom. He picked up on the first ring. He already knew. Tom's voice was steady, the way it always got when things were actually happening. Fire started at the bottom of Ridgeback Road, moving northeast up the canyon. Wind is pushing it hard. Cal Fire has one engine on scene, requesting mutual aid. Daniel, it's going toward the ridge. I looked down the hallway at the courtroom door. I could hear Judge Castillo's muffled voice beginning the session again. I went back inside. I sat down next to Priya and showed her my phone screen. The Cal Fire incident page: Ridgeback Road fire, 0% contained, northeast spread. She read it. Her expression didn't change. She leaned over and said very quietly, "Do you need to go?" I said, "My system is running." She said, "Then we stay. This is where we finish it." Tom Cafferty was the first witness. He took the stand and spent 40 minutes describing, in the measured language of a 22-year wildland firefighter, exactly what my system could do in an active fire scenario. He explained pressure curves, activation windows, structure ignition sequences. He explained what happens to a home on a ridge when a fire approaches and the municipal water pressure has collapsed. He explained what doesn't happen to a home that has its own pressurized suppression system operating independently of municipal supply. The jury was very still. Sandra's attorney cross-examined Tom for 20 minutes, trying to establish that rooftop suppression systems were unproven and not standard practice. Tom looked at him the way a person looks at someone who's asked them to explain something very basic and said, "With respect, counsel, the after-action reports from the Tubbs fire and the Camp Fire both specifically note that structures with active water systems had significantly higher survival rates. Those aren't my opinions. Those are Cal Fire's published findings." Sandra's attorney moved on. During the lunch recess, I checked the Cal Fire app. The Ridgeback Road fire had grown to 47 acres. Wind-driven, 0% contained. Cal Fire had escalated to a full response, 2 Type 1 engines, 1 Type 2, and a request for air support. The incident map showed the fire moving northeast, toward Ridgeback Lane, toward the ridge, toward Sycamore Pines. I showed Priya. She said, "How long?" I said, "If the wind holds and containment fails, 2 hours. Maybe less." She said, "We'll have our case in front of the jury before then." The county building inspector testified after lunch. He was 53, gray-haired, and utterly unflappable. He went through every permit, every inspection, every certification. He explained in plain language that my system had been reviewed at every stage, passed every inspection, and was fully compliant with all applicable county codes. He said, "In 21 years of building inspection, This was one of the most thoroughly documented residential installations I've reviewed. Sandra's attorney had no meaningful cross-examination. He asked 2 questions and sat down. During the mid-afternoon recess, my phone showed the incident update. Ridgeback Road fire, 215 acres, 0% contained. Mandatory evacuation orders in effect for 3 neighborhoods in the fire's projected path. Ridgeback Ridge was in the next zone, evacuation warning, not yet mandatory. I texted Carol, fire moving. Be ready to leave but not yet. System is running. She texted back, I'm watching the news. I see it. The system's green on the app. I texted back, I know. That's why we stay. Derek Osmond took the stand at 3:15. He was gray-faced and avoided looking at the gallery. His cooperation agreement was in evidence. Priya walked him through his role, the audit, the plans he'd received from Sandra, the Tuesday evening visit to my property, the relay bypass, the $3,000 in cash. He answered every question in a flat, defeated voice. He did not equivocate. He was a man paying the price for a bad decision made on behalf of someone who would not be sharing that price. When Priya asked him, who gave you the installation plans and told you what the relay switch did? Osmond said, Sandra Hollis. When she asked, who paid you the $3,000? He said, Sandra Hollis in cash, in 2 envelopes. When she asked, did you understand that bypassing that relay would disable the fire suppression system? Osmond looked at the floor for a moment and then said, yes. The courtroom was absolutely silent. I heard the air conditioning. I heard someone in the gallery shift in their seat. Sandra's attorney cross-examined Osmond hard, attacking his credibility, his cooperation agreement, his motives for testifying. Osmond took it without deflecting. He'd made a deal and he was honoring it. The cross-examination lasted 40 minutes and I thought it actually made things worse for Sandra. Every hard question Osmond absorbed calmly and answered directly made him look more credible, not less. By the end, Sandra's attorney looked like a man who'd understood too late that this witness couldn't be rattled. At 4:45 p.m., the judge called an early recess. She'd received a message from court staff that the evacuation warning for Ridgeback Ridge had been upgraded to a mandatory evacuation order. Several jurors lived in the affected area. The recess was for 30 minutes to allow people to make arrangements for family members. I checked the incident update. Ridgeback Road fire, 680 acres, 0% contained. Wind at 28 miles per hour sustained, gusting to 41. The incident commander had requested 2 additional aircraft. In the courthouse hallway during the recess, Sandra stood near a window at the far end, looking at her phone. Her attorney was beside her, speaking in a low voice. I watched her from 40 feet away. Her face, for the first time, showed the calculation had broken down. She was looking at something on her phone screen and her expression was, I don't have a better word for it, exposed, like a structure when the outer wall comes down and you can see the interior. I went back to the courtroom when the recess ended. One juror had been excused. Her house was in the mandatory evacuation zone and her husband was elderly and couldn't get out alone. Judge Castillo brought in an alternate. Court resumed at 5:20 p.m. Outside the courthouse, I'd been told by a deputy sheriff in the hallway, the air quality in Riverside was dropping fast and smoke was visible from the courthouse parking lot. But inside the courtroom, under fluorescent lights, we had a job to finish. Priya called Brenda Kowalski as the next witness. Brenda was not on trial. She was a fact witness whose declaration, Sandra said she'd found a way to demonstrate that Marsh's system doesn't work, was already in evidence. On the stand, Brenda confirmed the declaration. She looked at Sandra once, briefly, and then looked away and did not look at her again. She answered Priya's questions in a clear, sad voice. The sentence about Sandra's comment hung in the courtroom air. Sandra's attorney objected twice. Both objections were overruled. The day's testimony ended at 6:30 p.m. Judge Castillo adjourned until the following morning, noting that the fire situation was being monitored and that if conditions required, proceedings could be moved or continued. I walked out of the courthouse into air that smelled of smoke. The western sky had a bronze-orange tint that I recognized, not sunset, the wrong color for that. Firelight reflected off particulate. I looked at my phone. Ridgeback Road fire, 1,400 acres, 5% contained. The containment line was holding on the south flank. The north flank, the ridge side, was not. I called Tom from the courthouse parking lot. He was at the staging area at the Route 9 fire station, where he'd gone after his testimony with his old CAL FIRE gear in the truck, offering to help however he could. He said the fire spread rate was being driven by the wind funneling up the canyon, and the forecast showed the wind holding through midnight at minimum. He said, "The question is whether containment can be established on the ridge side before the fire gets to the interface." I said, "And if it can't?" He said, "Then your system matters more than this trial." Carol had evacuated with our neighbor Arthur Lim and his wife in the early afternoon when the warning came. I'd arranged this with Arthur a month ago as part of a neighborhood preparedness plan. She texted me from their daughter's house in Murrieta. "We're safe. Watching the news. Your system is still showing green on the app. The whole neighborhood is watching." I read that 3 times. The whole neighborhood, including Sandra's neighbors. I drove back toward Ridgeback Ridge as far as the evacuation checkpoint at Canyon Road, which was as close as civilians were being allowed. From there I could see the fire line on the ridge above, an orange serration against the dark sky, moving with the wind. The containment line the CAL FIRE crews had been working on the north flank was visible as a break in the brush, but the fire was moving faster than the crew could cut. I watched from the hood of my truck and ran the math I'd been running for 11 years. The fire was going to reach the interface. The question was what it found when it got there. At 11:30 p.m., the Ridgeback Road fire crossed the ridge line and entered the Sycamore Pines interface zone. I know this because the CAL FIRE incident app updated, because Tom texted me from the staging area, and because I could see it from where I was parked. A bright orange front advancing through the chaparral above the community, throwing embers ahead of the main flame. In every fire behavior model I'd studied, this was the moment the variables collapsed into one question. Does the structure survive or doesn't it? At 11:47 p.m. my phone showed the suppression system app. Primary array activated. The heat sensors on the west fence had triggered at 11:46, and the pump had fired within 4.2 seconds. Exactly as tested. The roof perimeter sprinklers were running. The west fence line was running. 2 years of engineering, 11 months of litigation, and 1 act of sabotage that hadn't worked. And the system was doing what it was designed to do in the dark without me on the worst fire night the ridge had seen. I sat on the hood of my truck and watched the incident app. Tom texted, "Your sensors tripped. System is up. I can see the spray from the staging area." That was the moment I understood something about 11 years of preparation. That the point is not the fight to protect the preparation. The point is the preparation itself. Sandra had tried to litigate it, regulate it, sabotage it, and buy it, and here it was at 11:47 p.m. doing its job. What my system could not do was protect Sandra's street. Pinecrest Lane, where Sandra's house sat, was the northern edge of the Sycamore Pines interface, the first point of contact when a fire came over the ridge from the north. Sandra had no suppression system. Her neighbors had no suppression system. The Italian cypress trees she'd planted to block her neighbor's view were, in fire behavior terms, vertical fuel ladders standing 6 feet from her roofline. I learned what happened on Pinecrest Lane from Tom and from the fire marshal's report that came out 6 weeks later, but also from the incident reports filed that night, which I eventually obtained through a public records request. The fire reached the north end of Pinecrest Lane at approximately 12:15 a.m. A CAL FIRE engine was stationed at the intersection of Pinecrest and Ridgeback, but with municipal water pressure severely degraded, every hydrant in the area was open. The crew's capacity was limited. The cypress trees on Sandra's property caught first. The fire marshal's report noted that combustible vertical vegetation within 6 feet of the structure significantly accelerated ignition. Sandra's house sustained major damage, approximately 60% of the structure. The 3 adjacent homes on Pinecrest Lane, all belonging to HOA board members who had voted for my remediation order, Ron Feltner, Brenda Kowalski, and a third member named Vince Gallagher who'd been a reliable Sandra vote for 3 years, also sustained significant damage. No one was killed. Everyone had evacuated in time, but the houses were gone or functionally gone, and in the morning light what remained of Pinecrest Lane was a line of scorched stucco and ash. My house was standing, every window intact. The oak tree Marcus had grown up beside was slightly singed on the west-facing bark but structurally sound. The sensor mounts Sandra had spent 18 months trying to remove were still standing on the fence posts. System status app showing standby. Fire event concluded. The tank was at 31% capacity. The secondary backup array, the one Sandra never knew about, had never needed to activate. The primary system had been enough. I drove up to my street when the evacuation order was lifted at 6:30 a.m. The checkpoint deputy recognized me from the night before and waved me through without a word. I drove slowly up Ridgeback Lane, past the soot-darkened fence lines and the ash-covered driveways, and turned into my driveway. I sat in the truck for a moment. Then I got out and walked the perimeter of my house. Every wall, every window, the roof, the fence, the sensor array, all of it standing. Tom was waiting in my backyard when I came around the side of the house. He'd gotten through the checkpoint on his fire service credentials. He was standing by the west fence looking at the suppression system with the expression of a man who had spent 22 years in wildland fire and had just seen something he'd calculated but hadn't been certain about until this moment. He said, "It held." I said, "It held." He said, "The whole line." I said, "The whole line." We stood there for a moment and didn't say anything else. The fire marshal, Jim Carver, came to my property at 9 a.m. for an initial assessment. He was a lean, careful man who walked the fence line and the roof perimeter twice before speaking. He asked me for the system specs and activation logs. I handed him the printed specs and the system app's activation history. Trigger time, pump activation time, pressure curve, run duration. He studied it for a long time. Then he said, "Mr. Marsh, your system prevented structure ignition on approximately 300 feet of wildland interface." He said it with the cadence of a man who had spent a career writing reports about what hadn't been there when it should have been. Fire Marshal Carver then walked toward Pinecrest Lane to continue his assessment. He stopped at my fence line and turned back. He said, "One more thing. I understand there was an HOA dispute about this system." I said yes. He said, "I'm going to note in my report that the removal of this system, had it occurred, would have resulted in high probability of structure loss for this property." He said, "I'm also going to note that the absence of equivalent systems on adjacent properties was a contributing factor in those structure losses." He turned and walked away. Sandra's first public statement came through her attorney, issued that afternoon. She was devastated by the losses in the community and was grateful that all residents had evacuated safely. The statement made no mention of the litigation. It made no mention of the trial scheduled to resume the following morning. It made no mention of my system, of the HOA dispute, of Derek Osman, or of anything that had happened in the preceding 18 months. It was the statement of someone trying to exist only in the present tense. The statement didn't land well. By that afternoon, 3 local news outlets had connected the Ridgeback Road fire to the pending litigation over my wildfire defense system. A reporter named Laura Chang at the Riverside Press Enterprise had been following the civil case and had a 4-month-old court filing with the full story of the panel tampering and Osmond's cooperation agreement. She published at 3 p.m. The story included the fire marshal's preliminary statement. It included a photo of my house, standing, taken from the Pinecrest Lane ash field. I didn't read the article until that evening. I was busy, talking to Carol, who drove back from Marietta, talking to Marcus, who'd been texting since midnight, walking the property one more time with Tom, giving a preliminary statement to Deputy Reyes, who came by to document the fire event in relation to the open criminal investigation. By the time I sat down and read Laura Cheng's article, it had already been shared more than 4,000 times. The article's headline was, HOA ordered removal of fire system that may have saved Ridgeback home. The subheadline referenced the tampering investigation. The article quoted the fire marshal's preliminary assessment, quoted Tom Cafferty. It quoted Judge Castillo's admonishment from the contempt hearing. It quoted 3 neighbors who described the HOA dispute. It did not quote Sandra. Her attorney had declined to comment. By that evening, the story had been picked up by local television. A crew from the ABC affiliate in Los Angeles was parked on my street by 7 p.m. I gave a brief statement on camera, measured, factual, no editorializing, just as Priya had trained me. I said that my family was grateful the system had worked, that we were grateful no one had been hurt, and that we hoped the community could rebuild. The reporter asked if I had anything to say about the HOA. I said the legal process would speak to that. She asked if I was angry. I thought about it for a moment. I said, I'm relieved. That was the honest answer. Sandra did not appear on camera. Her attorney issued a second statement late that evening. Ms. Hollis wishes to convey her deep concern for all affected residents and maintains full confidence in the legal process. The phrase full confidence in the legal process was doing a lot of work in that sentence. Given that the legal process now included a cooperation agreement from her hired saboteur and a criminal referral to the DA's office. Ron Feltner called me at 9 p.m. I almost didn't answer. I answered. He was calling from his daughter's house in Temecula, where he'd evacuated with his family. His house was substantially damaged. He said, Daniel, I'm sorry. I'm sorry for all of it. I said I appreciated him calling. He said, I sent that email for her. She said the switch was a test, not a sabotage. She said it would just show your system wasn't as reliable as you claimed. I believed her. I was quiet for a moment. Then I said, Ron, you need to talk to an attorney. He said he already had. I said good night. Brenda Kowalski texted me at 10 p.m. I saw your house on the news. I'm glad it's standing. I'm sorry mine isn't. I read that text 3 times. I didn't know what to say to it. I typed, I'm sorry too, Brenda, and sent it because it was true. Her house was gone. She'd voted against my system for the wrong reasons, but I didn't think she was a bad person. I thought she'd made a series of small choices in Sandra's orbit that led somewhere she never intended. That can happen to people. It doesn't excuse it, but it's what happened. Phil Okafor's house was undamaged. He lived on the south end of the community, far from the fire's entry point. He called me Wednesday morning and said, I always hoped you were wrong about the risk level, Daniel. I'm sorry you were right. I said I'd been hoping to be wrong too. He said, what happens now? I said, court tomorrow. Then whatever comes after. The national press arrived Thursday morning. Fire stories travel fast, but fire stories involving a HOA sabotage investigation and one intact house in a row of ash-covered lots, those travel faster. By 8 a.m., there were 4 satellite trucks on Ridgeback Lane. Carol counted them from the kitchen window and reported back to me with the calm of someone who'd decided there was nothing left to be surprised by. Laura Cheng's original story had been picked up by the AP, then by CNN, then by 3 national newspapers. The framing was consistent. A homeowner builds wildfire defense. HOA tries to destroy it. Sabotage is alleged. Fire comes. Defense works. It was a story that wrote itself, and the reason it wrote itself was that it was true. Every detail in order exactly as it had happened. I documented all of it. 18 months of documentation, and every page of it was now available to every reporter who filed a records request with the Riverside County Court. I drove to the courthouse Thursday morning through a city that smelled of smoke. The satellite trucks had moved from my street to the courthouse parking lot overnight. Priya met me at the entrance with coffee and a look I'd learned to read as focused intensity with a thin layer of something that might, in better circumstances, have been excitement. She said, "How do you feel?" I said, "Ready." She said, "Sandra's attorney requested a private conference with the judge this morning. First thing." I said, "What does that mean?" She said, "It means this trial might be shorter than we thought." The private conference between Sandra's attorney and Judge Castillo lasted 20 minutes. I sat in the hallway with Priya and her paralegal and a banker's box that suddenly felt heavier than it had the day before. I watched the courtroom door. I didn't check my phone. I was done checking my phone. Whatever was going to happen in that room, and I was going to be present for it. Sandra's attorney came out first. He walked past me without making eye contact and went to speak with Sandra, who was seated at the far end of the hallway bench. I watched their conversation from a distance, the body language of a man delivering information his client did not want to receive. Sandra's posture, which had been rigid all morning, changed as he spoke. I watched something go out of her, some last structural tension, like a wall settling after a long time under load. Priya was called into the judge's chambers 15 minutes later. She went in with her notepad and came out 22 minutes after that. She sat down next to me and said, "Sandra wants to settle." I said, "On what terms?" Priya said, "All of them, every term. She's prepared to drop the remediation order, pay our legal fees in full, dissolve the HOA's claim against the system, issue a formal written acknowledgement that the system was validly permitted and properly installed, and pay civil damages for the panel tampering." I said, "And the property?" Priya said, "She's not asking for the property." I said, "What happened?" Priya said, "The DA's office contacted her attorney this morning. The criminal referral has been accepted. They're opening a formal investigation." She paused. "And Craig Witowski's attorney contacted hers last night. He's withdrawing from any development discussions in Sycamore Pines. Completely." I sat with that for a moment. Then I said, "Do I want to settle?" Priya said, "That depends on whether you want a judgment on the record or whether you want it to be over." I said, "Tell me what the judgment would say." She told me. I asked for 10 minutes. I walked down the courthouse hallway to a window that looked out over the parking lot, where I could see the satellite trucks and a small cluster of reporters near the entrance. Somewhere behind me in the hallway was Sandra Hollis, and whatever she was experiencing in this moment was, finally, not my responsibility to manage or account for. I thought about the relay switch in bypass position. I thought about Osman's flat voice on the stand. Yes, I understood that bypassing that relay would disable the fire suppression system. I thought about the fire marshal standing on my driveway saying, "Approximately 300 feet of wildland interface." I thought about Marcus calling from Portland at midnight asking if the house was okay. I went back to Priya and said, "I want the judgment on the record." We went back into the courtroom. The jury was seated. Judge Castillo entered at 9:47 a.m. and called the session to order. Sandra's attorney stood and said, "Your Honor, the defense withdraws all opposition to the plaintiff's claims and consents to a judgment in the plaintiff's favor on all counts." The judge looked at him for a moment. Then she looked at Sandra. Sandra sat at the defense table with her hands folded on the surface and her eyes focused on something that wasn't in the room. The judge said, "The court notes the withdrawal of opposition. We will proceed to a formal judgment." She turned to the jury. "Ladies and gentlemen, this case has been resolved. I will dismiss you with the court's thanks." The jury filed out. Several of them looked at me on the way. The retired county inspector, juror number 6, gave me a nod as he passed. The woman who'd lost a friend in the campfire, juror number 3, paused briefly at the door and said, quietly, "I'm glad your house is okay." Then they were gone, and the courtroom held only the people who were directly part of this. Priya and her paralegal, Sandra and her attorney, Judge Castillo, and me. Judge Castillo read the judgment into the record. The HOA's remediation order was vacated. My system was formally recognized as a validly permitted residential fire suppression system, whose maintenance and operation were protected under California law. The HOA was ordered to pay my attorney fees, which Priya had documented at $87,400. Sandra Hollis personally was found civilly liable for the panel tampering and ordered to pay damages to be assessed separately. The judge's voice was precise and even throughout. She read it like a person reading a document that had taken a long time to arrive and was now, finally, exactly what it should be. After the judge finished, she did something I hadn't expected. She removed her reading glasses, set them on the bench, and looked at Sandra directly. She said, "Ms. Hollis, I want to make something clear for the record. The equipment you sought to remove, and ultimately to disable through criminal means, protected a family's home during an active wildfire. It worked because Mr. Marsh built it, maintained it, and refused, over 18 months of concerted pressure, to remove it. I hope the community you represent takes careful note of that fact." Sandra said nothing. Her attorney said nothing. The judge put her glasses back on and called the session closed. I stood outside the courthouse at 10:23 a.m. on a Thursday in June, 18 months after I'd received the first violation notice from Sandra Hollis, and for approximately 40 seconds I didn't do anything except stand in the smoke-tinged air and let the morning be what it was. Priya came out beside me. She didn't say anything either. Then she put her hand out and I shook it and she said, "Well done." I said, "We did it right." She said, "You did it right. All of it. Every document, every step." I said, "And the backup array." She looked at me. "You never told me about the backup array." I said, "You never needed to know. Tom was waiting by my truck. He'd been following the courthouse steps on his phone and knew the outcome before I reached him. He shook my hand for a long moment without speaking, which is the Tom Cafferty version of a standing ovation. Then he said, "You want to go home?" I said yes. We drove back up Ridgeback Road in my truck, windows down, and the air was still smoky but not the emergency smoke of the night before. It was the morning after smoke still settling. We passed the Route 9 fire station where the Cal Fire engines were cleaning up. A crew member waved from the apparatus bay. The scene on my street when we arrived was more than I'd prepared for. 7, maybe 8 neighbors were standing in front of my house when I pulled up. People I'd barely spoken to during 18 months of litigation. People who'd attended that first HOA meeting and voted against Sandra's amendment and then gone quiet. Denise Farrow was there. Arthur Lim and his wife. 2 families from the south end of the ridge whose houses hadn't been touched by the fire. They stood in my driveway and they looked at my house, intact, every wall, every window, and then they looked at me and I didn't know what to say, so I just got out of the truck and stood there with them. Denise was the one who spoke first. She said, "We should have backed you harder." It was a simple sentence. I said, "I know why you didn't." She said, "That's not an excuse." I said, "No, but it's an explanation." She hugged me then, which surprised me, and I let her, because it was genuine and because I was tired of calibrating things. Arthur Lim said, "What do we do about the HOA?" I said, "Phil Okafor would be a good board chair, if he's willing." Arthur said, "I'll ask him." And that was, in the most practical sense, the end of the Sandra Hollis era in Sycamore Pines. Carol arrived from Murrieta at noon. She drove up to the house, parked in the driveway, got out and walked the perimeter, the whole thing alone once around the house before she said a word to me. When she came back to where I was standing, she put her hands on my face and looked at me with an expression I recognized from 24 years of marriage. The expression of someone who has been carrying the weight of something for a very long time and is now, carefully, setting it down. She said, "I told you the system would work." I said, "You told me not to celebrate too early." She said, "Same thing." We went inside. Marcus called at 2 p.m. He said, "Dad, you're on CNN." I said, "I know." He said, "How do you feel?" I said, "I feel like I need to sleep for about 3 days." He said, "Is the house really okay?" I said, "Come see it." He said he was booking a flight for the weekend. He sounded the way he used to sound when he was 12 and something had turned out better than expected. That specific relief that kids have when adults solve the thing that's been scaring everyone. He's 31 now. Some things don't change. The news cycle ran hard for 2 days. Laura Cheng's story was the anchor, but every major national outlet had their own version by Friday. The narrative was consistent and, because it was built on 18 months of court records and fire marshal documentation, more or less accurate. A homeowner builds protection, HOA tries to destroy it, the protection survives anyway and does its job. The camera-friendly contrast, one standing house, a row of damaged ones, made the visual story tell itself. Sandra did not speak to the press. Her attorney issued one more statement Friday afternoon. She was cooperating fully with all applicable investigations and had the deepest sympathy for all Sycamore Pines residents affected by the fire. She would be making no further public comment at this time. It was the statement of someone whose attorney had told her that anything she said would be used in a criminal proceeding. The Riverside County DA's office confirmed Friday that Sandra Hollis was under formal criminal investigation for tampering with fire safety equipment and related charges. The statement named her by name, which DA offices don't always do at the investigation stage. I called Priya when I read it. She said, "They're signaling that the case is solid." I said, "Or they're watching the news cycle." She said, "Both things can be true." Derek Osmond's cooperation agreement was unsealed Friday afternoon. The local news covered it with the thoroughness of a community that had just watched its ridge burn and was now assembling the narrative of why. 3 homeowners on Pinecrest Lane, 2 of them who'd had their houses substantially damaged, gave statements to local media saying they hadn't known about the panel tampering until the news stories ran. One of them said, "If I'd known someone disabled the fire system up there, I would have demanded the HOA fix it." He meant my system, that dismantling my system and removing protection from the interface had made his property more vulnerable. He was right. The fire marshal's report would eventually say exactly that. Ron Feltner gave a formal interview to Deputy Reyes on Friday, with his attorney present. I don't know the full content of that interview, but Priya was informed by the DA's office that Feltner had provided a complete account of the events surrounding the email and the panel, corroborating Osmond's statement. Feltner was offered consideration in exchange for his cooperation. He took it. He was the kind of person who, when he finally saw clearly what he'd been part of, couldn't live with the alternative. Saturday was the first day that felt cautiously like after. Carol and I had coffee on the back porch in the morning. The first time we'd done that in weeks without me checking the system app every 5 minutes. The oak tree threw its shadow across the yard. The west fence line was intact. 2 sensor mounts, still standing, system in standby mode. I looked at them for a long time and felt something I can only describe as the specific satisfaction of a thing having worked the way it was designed to work. Tom came by Saturday afternoon with his wife, Maria, who'd brought tamales, which is the San Bernardino County version of condolences and congratulations simultaneously. We sat on the back porch and ate and talked about things that weren't the HOA or the fire or the litigation. Tom's dogs ran in the yard. Carol's laugh, which I hadn't heard in its full version for months, came back at something Maria said. I filed the sound away. Phil Okafor called Saturday evening. He'd been in conversation with several other homeowners and was willing to take on the board chairmanship if the community wanted him. He said a recall election for the remaining board members was already being organized, Brenda and Ron and Vince Gallagher, who'd all voted for the remediation order. Phil said it would be clean and fast. He said, "Daniel, I want to ask you something." I said, "Ask." He said, "Would you consider serving on the board?" I said, "No." He said, "Why not?" I said, "Because I'm going to build a better system and I need the time." He laughed. It was a good laugh. Sunday I walked Pinecrest Lane for the first time since the fire. I went alone, in the morning, before the street was busy. The damage was extensive, 3 houses substantially destroyed, 2 more with significant structural loss. Debris cleared to the curb by county crews. Sandra's cypress trees were gone. Burned to the base, 6 black stumps in a row where the ladder fuel had stood. Her house was still standing but gutted, the front facade intact, the roof and interior compromised. I stood in front of it for a moment. I felt no satisfaction about the house. I felt something closer to the recognition of consequence, that things have consequences, and that the consequences had fallen, this time, in the geographically accurate direction. What I felt something closer to satisfaction about was the fire marshal's preliminary report, which had been released Saturday and which I read that Sunday morning on my phone, standing on what remained of Pinecrest Lane. The report found that structure ignition on the north end of the community had been significantly influenced by the presence of combustible vertical vegetation adjacent to structures, and that the absence of active suppression systems on affected properties was a contributing factor in fire spread. It found that my property had benefited from a functioning residential wildfire suppression system that activated appropriately and prevented ignition. It found, and this was the sentence I read 3 times, that removal of said system, as ordered by the HOA but enjoined by court order, would have resulted in high probability of structure loss. The injunction had saved my house. My own system had saved my house. And Sandra's trees had helped burn hers. I walked back up Ridgeback Lane to my house. My neighbor 2 doors north, a woman named Carmen Reyes who'd been largely neutral throughout the dispute, was sweeping ash from her driveway. She looked up when I passed and said, "Mr. Marsh, I want to apologize." I stopped. I said I appreciated it. She said, "I voted yes on the amendment at the original meeting, the first one that failed. I voted to classify your system as a prohibited structure." I said I knew. She said, "I didn't understand what it was." I said, "You do now." She went back to sweeping. I went home. The HOA's board held an emergency meeting Monday, the first since the resignations, with only Brenda, Ron, and Vince Gallagher present, Sandra having already been asked by the HOA's own attorney to step aside pending the criminal investigation. The 3 remaining members voted unanimously to formally withdraw all HOA actions against my property, to rescind the remediation order, and to retain a new attorney. The vote was recorded in the minutes. The minutes were distributed to all 47 homeowners. Phil sent me a copy with a 1-line note. It's over. I wrote back. Phase 1. Phase 2 was the criminal process, which moved on its own timeline and which I had limited visibility into but could follow through the DA's public releases. Sandra was formally charged 6 weeks after the fire. The charges included criminal tampering with a fire safety system, conspiracy, and 2 counts related to the insurance complaint. Derek Osman had already entered his plea. Ron Feltner's cooperation had produced additional documentation. Sandra's attorney entered a not guilty plea on her behalf. The arraignment was brief and was covered by 4 television crews. What I hadn't known, what I wouldn't learn until much later, from a reporter who'd done more digging than any of the original stories, was one more detail about Sandra's arrangement with Craig Witowski. The development plan he'd withdrawn from wasn't just a short-term rental cluster. It was a partial subdivision, an application to split 6 existing properties on the ridge, including mine and Tom's, into smaller parcels with different zoning. The underground tank on my hillside sat on property that, under the proposed split, would have become a separate lot valued at roughly twice the residential acreage rate. Sandra had a commission agreement with Faye Dunlap on that specific lot. The tank, the system, the permit, these weren't just aesthetic problems for the development. They were legal encumbrances on the land Witowski wanted to sell. The system had to go because the land had to be clear. I sat with that information for a long time. Then I filed it in the binder with everything else. 7 weeks after the fire, I met with Fire Marshal Carver again. He was finalizing his report and wanted to walk the property one more time. We went through the system together. He asked technical questions, I answered them. At the end of the walk, he told me the department was going to cite my installation as a model in their next community preparedness presentation. He asked if I'd be willing to speak at it. I said yes. He said, "People need to see that this works." I said, "That's why I built it." I spoke at the Cal Fire Community Preparedness event in September. The room held maybe 200 people, homeowners from across Riverside County, a mix of concern and curiosity and the specific alertness of people who've watched their region burn too many times to be complacent. I talked for 30 minutes about the system design, the installation process, the permit requirements, the maintenance protocol. I talked about what it cost. I talked about what it did. I talked about what it didn't do. It wasn't a substitute for evacuation, for defensible space, for the full range of preparation. But it was one more layer, and layers matter. Afterward, 11 people asked for my contact information. I gave it to all of them. Tom and I spent October building a version of the system for Carmen Reyes, who'd asked me in September if I'd help her put one in. We pulled the permit, designed the layout, and did most of the installation ourselves over 3 weekends. Her property had a different exposure than mine. More southern slope, less direct western interface, and we adapted the array accordingly. Tom said, "This is what you do next. You help everyone else build theirs." I said I'd thought about that. He said, "I know. You've been thinking about it since 2021. He was right. I drove past Sandra's house in November, 3 months after the fire, on my way to the building department to pull the permit for Carmen's system. The repair work had started. A contractor crew was on the roof, new framing going up on the east side of the structure. The cypress stumps were still in the front yard, not yet removed. I didn't stop. I drove past and thought about what it cost to be Sandra Hollis in that neighborhood now. The criminal case, the civil judgment, the community she'd built and run for 7 years now, mostly looking at her the way people look at something that had seemed solid and had turned out to be hollow. I didn't feel triumphant about it. I felt something more like the quiet that comes after a long, loud thing finally stops. The HOA elected Phil Okafor board chair in October. He ran unopposed. 2 of the new board members were people who'd said nothing during the 18 months of dispute, and who came to Phil's first meeting with the energy of people who had things they'd been waiting to say. One of them proposed an amendment to the CC and RS explicitly permitting and encouraging installation of wildfire suppression systems. The amendment passed unanimously. Phil sent me the meeting minutes. I put them in the binder with everything else. The binder was getting very full. Carol found me at my desk one evening in November reviewing some of the earlier documentation. The first violation notice, the original email from Sandra asking me to clarify the nature of the structures. She sat down across from me and asked what I was doing. I said I was thinking about writing something, not a legal document, but an account. Everything that had happened in order for anyone who might be building a system of their own and facing a HOA that didn't want them to. She said, like a guide. I said, more like a warning. She said, who for? I said, for the next person who builds something that matters and has to fight to keep it. She nodded. She went to make tea. I started writing. Sandra's criminal trial was set for the following spring. I wasn't a named victim in the criminal case, the state was the party, and I was a witness. But I followed it the way you follow anything you've been living inside for 2 years. Closely, with attention to every procedural detail, and with the constant awareness that the outcome mattered in ways that went beyond me. The preliminary hearing in December was where the state laid out its case for the judge to determine whether sufficient cause existed to proceed to trial. The DA's lead prosecutor was a woman named Sylvia Huang, who had the manner of someone who had spent 15 years making complicated things clear to judges. I sat in the gallery and watched her work and thought that Sandra had underestimated what she was up against from the beginning. Not just me, but the nature of paper trails and the way institutions respond when someone has used their infrastructure to do damage. Sandra's defense team, she'd replaced her civil attorney with a criminal specialist named Warren Klein, argued at the preliminary hearing that the tampering charge required proving Sandra had directed Osmond to disable a fire suppression system as legally defined, and that the panel's relay switch didn't meet the statutory definition. It was a technical argument that sounded, in the abstract, potentially viable. Judge Castillo, who had been assigned the criminal case on a related proceedings basis, was not persuaded. She found probable cause on all counts. The trial was set for April. Between December and April, Sandra tried twice more to negotiate a plea. Both times she offered guilty pleas to lesser charges with no jail time. Both times Sylvia Huang declined. I was told this by Deputy Reyes, who was on the prosecution's witness list along with Tom, me, Derek Osman, Ron Feltner, and Fire Marshal Carver. I asked Reyes why Huang was refusing the lesser pleas. He said, "She wants the jury to hear the whole thing." I said, "Good." January brought rain, the first substantial rainfall of the season, saturating the charred hillsides above sycamore pines and producing the mudslide risk that follows every major fire in Southern California. I spent 3 weekends reinforcing the drainage channels on my west hillside, which my system's installation had partially altered. The work was muddy and unglamorous and completely absorbing. Tom helped. We talked about the drainage more than we talked about anything else. It was, in an odd way, one of the better periods I'd had in years. February brought a development I hadn't anticipated. 2 families on Pinecrest Lane filed civil suits of their own, naming Sandra and the HOA as defendants for damages related to their structure losses. Their theory, built with their attorney's skill on the fire marshal's report, was that Sandra's actions in pursuing the remediation order against my system, and the panel tampering specifically, had contributed to the conditions that allowed fire damage to their properties. It was a novel legal theory, and Priya told me it was a genuine long shot. But it was on the record now, and the filing had been covered by Laura Chung, and the families had stood on their ash-covered lots and talked to cameras, and the story kept growing its own roots. Craig Witowski's withdrawal from the Sycamore Pines development had been complete and documented. But in March, a real estate trade publication ran a profile of his company that mentioned, briefly, in a sidebar, that his planned Ridgeback Ridge project had been disrupted by legal complications including a wildfire safety dispute. The profile didn't name Sandra. It didn't need to. The connection was there for anyone who looked. I read the profile twice and thought about what Sandra had been willing to do for a development deal that hadn't even been finalized yet. The $3,000 she'd paid Osman. The insurance complaint. The rigged audit. The 7 years of HOA control she'd built and then spent in one direction. All of it for land she'd never controlled and money she'd never received. The criminal trial opened in April with jury selection that took 3 days. I was sequestered as a witness and couldn't follow the selection directly, but Priya attended as an observer and reported that the prosecution and defense had both been meticulous. The seated jury was 8 women and 4 men, ranging in age from 29 to 68. 3 of them lived in HOA communities. 1 of them had a house in the Angeles National Forest area. Sylvia Huang had liked this jury. Warren Klein had liked it less. I testified on the 3rd day of trial. I'd been a witness before at the civil proceedings, but this was different. This was a criminal courtroom with a different kind of weight to the air. I told the story the way Priya had trained me and Sylvia had subsequently coached me. In order, with specificity, without drama. I described the system, the dispute, the notice of Osman's presence, what I found in the panel, what the relay position meant. I answered every question directly. On cross-examination, Warren Klein tried for 40 minutes to establish that I had no proof Sandra had directed Osman specifically. I agreed I'd had no direct proof at the time. I said that was why I'd reported it to law enforcement and let them develop the evidence. Klein moved on. He knew when a witness wasn't going to give him what he wanted. Tom testified the following day. He described the system's function, what the relay bypass meant in operational terms, and what would have happened to my structure if the fire had reached the interface with the system disabled. He was asked by Sylvia Huang, in your professional assessment, as a 22-year wildland firefighter, would this home have survived the Ridgeback Road fire without a functioning suppression system? Tom said, no. In my professional assessment, it would not. Klein objected. The objection was overruled. Fire Marshal Carver's testimony was the most technically complete of the trial. He spent 4 hours on the stand, 2 days, walking the jury through his investigation methodology, his findings, and his conclusions. He presented the activation logs from my system. He presented the photographic record of the fire damage on Pinecrest Lane. He presented the comparison. Structures with no suppression system, damaged or destroyed. One structure with a functioning suppression system, intact. He presented the fire behavior modeling showing what would have happened to my property if the system had been in bypass mode when the fire arrived. The model showed structure loss with 91% probability. Klein cross-examined him for 3 hours. Every question got a factual answer. The jury took notes throughout. Derek Osman testified on day 6. He was, if possible, even more affectless than he'd been at the civil trial, the flat, cooperating monotone of someone who had made a decision and was executing it. He described receiving the installation plans from Sandra. He described Sandra explaining the relay bypass procedure to him. He described the $3,000 in cash. He described accessing my property through the gate combination Sandra had provided. Sylvia Huang asked him, when Ms. Hollis explained what the relay switch did she indicate that she understood this would disable the fire suppression function? Osman said, she told me it would make the system decorative. That's the word she used. Decorative. Decorative. That word sat in the courtroom for a long moment after Osman said it. I was in the gallery by that point. Witnesses were released after testimony, and I heard it clearly. Sandra was at the defense table looking at her hands. I watched her face. There was nothing readable in it. I thought about the word decorative, and about someone who had looked at a working fire suppression system and decided that the most important thing about it was that it was visible from the street. Ron Feltner's testimony was brief and covered, efficiently, his role in sending the anonymous email. He had cooperated and his cooperation was clean. Klein's cross was perfunctory. There wasn't much to work with. Feltner left the stand looking like a man who had spent 6 months not sleeping and was, at least, getting to put something down. Sandra took the stand on day 8. It was her choice to testify Warren Klein's. Really, since he'd clearly concluded that the weight of corroborated testimony against her required a direct rebuttal. She testified for 4 hours. Her account was that she had hired Derek Osmond to verify the operational status of my system, because she had genuine concerns about its reliability as documented. She said she had provided him the installation plans because she needed him to understand the system in order to evaluate it. She said she had not directed him to alter anything. She said the cash payments were for consulting fees paid in cash, because Osmond preferred cash payment. Sylvia Huang's cross-examination of Sandra lasted 6 hours over 2 days. It was, by every account of the reporters who covered it and the people who sat in the gallery, a surgical dismantling. Huang worked through every statement Sandra made and placed beside it the documented record. Osmond's statement, Feltner's email, the insurance complaints timeline, the Pacific Standards Group connection, Brenda's declaration, the settlement offer with the property sale provision. She placed each document on the projector and asked Sandra to explain the gap between her testimony and the record. Sandra was composed. She was consistent. She was, question by question, unable to explain the gaps. The cross-examination's turning point, the moment people in the gallery later described as the moment they knew, came on the second day, when Huang placed Osmond's statement on the projector and asked Sandra to read the sentence in which Osmond quoted her calling my system decorative after the relay bypass. Sandra read the sentence. Huang said, "Ms. Hollis, you've testified that you hired Mr. Osmond only to evaluate the system. Is decorative a word you would use to describe an operational fire suppression system?" Sandra said, "I don't recall using that word." Huang said, "Mr. Osmond recalls it specifically. He testified it was the word you chose." Sandra said, "He may be misremembering." Huang said, "He may be. Or you used a word that describes what you intended the system to become." Klein objected, sustained, but the word was in the air again. Decorative. It stayed there. Sandra's demeanor on the stand was, throughout, controlled. She never became visibly emotional. She never lost her composure in the way that jurors remember. But control and credibility are not the same thing, and what the jury saw was a woman whose account, placed alongside 4 separate corroborating witnesses, required believing that every one of those witnesses was wrong, misremembering, or motivated to lie. That's a lot to ask. Huang knew it was a lot to ask. Closing arguments were on a Thursday. Huang went first and she did what good prosecutors do. She told the story again in order, letting the documents be the punctuation. She ended with the activation log from my system, the timestamp showing the sensors firing, the pump responding, the suppression array running, and she said, "The defense will tell you that Sandra Hollis only wanted to evaluate Mr. Marsh's system. But you've heard what happened when that system was needed. It worked. It worked because the sabotage failed. The question for this jury is whether Sandra Hollis is responsible for the attempt." She sat down. Klein's closing was competent and built on the reasonable doubt standard, the absence of a direct order from Sandra captured on any recording, the question of whether Osmond's account might be self-serving, the possibility that the relay position had been set accidentally. He was thorough. He made the arguments that were available to him. They were not strong arguments because the facts were what the facts were, but he made them with the professionalism of a defense attorney doing his job in a case where his client had left him limited material. The jury deliberated for 11 hours over 2 days. I know because I watched the clock and checked my phone and sat with Priya and Tom in a coffee shop near the courthouse for most of those hours. Carol came down for the second day and sat with us. We didn't talk much. Tom did a crossword. Carol read a novel. I stared at the coffee table and thought about relay switches and fire behavior and the specific orange color of the sky the night the fire came over the ridge. The verdict came back on a Friday afternoon. I was in the courtroom for it. Sandra was at the defense table. Klein was beside her. The jury foreperson, the retired county inspector, juror number 6, who'd nodded at me on the way out of the civil trial, stood and read the verdict. Guilty on tampering with a fire safety system. Guilty on conspiracy. Guilty on 1 count of filing a false complaint with an insurance carrier. Not guilty on the 2nd insurance count. The jury had found insufficient evidence on the specific intent element. 3 of 4. The foreperson sat down. I watched Sandra when the verdict was read. For the first time in 2 years of watching her. Across HOA tables, across courtrooms, across parking lots. I saw something that wasn't calculation or composure or the specific alert stillness of someone managing a situation. I saw the face of someone for whom the situation had finally stopped being manageable. It lasted about 3 seconds. Then the composure came back, quieter this time, the composure of someone going somewhere they hadn't planned to go and deciding in real time how to carry themselves there. Sentencing was 6 weeks away. I walked out of the courthouse into a June afternoon, almost exactly 1 year after the Ridgeback Road fire, and stood on the steps for a moment. Tom was beside me. Carol took my hand. A few reporters asked questions and I answered them briefly. I was satisfied with the verdict. I hoped the community could continue rebuilding. I had no comment on what I thought the sentence should be. That was true. What the sentence was going to be was between Sandra and the court. I was done being in the business of Sandra Hollis. What I was in the business of, I'd decided over the preceding months, was building systems. Not fighting to keep them, building them, helping other people build them, making the case at every opportunity that the work people do before the fire matters more than everything else combined. Cal Fire had reached out through Fire Marshal Carver about a community partnership program. I'd agreed to participate. Tom was going to help. Carmen Reyes had been on the phone 3 times with neighbors who wanted to know how to start their own installations. Phil Okafor called the evening of the verdict. He said, "The community is grateful, Daniel. I know that sounds inadequate." I said it didn't sound inadequate. He said, "Sandra's house is going on the market. I think she's leaving the area." I said I'd heard that. He said, "How do you feel about it?" I thought about it. I said, "I feel like she should go somewhere with less fire risk." He laughed. Then he said, "I mean it, though what you did took something that most people wouldn't have." I said, "I had an engineer's certainty that I was right. That's not the same as courage." He said, "In practice, I think it is." Sentencing was at the end of July. I chose not to submit a victim impact statement. I thought about it, drafted one, and then decided it said things I'd already said in court and in 2 years of documentation. Let the record stand as the statement. The judge, not Castillo this time, a different judge for sentencing under the court's rotation, sentenced Sandra to 18 months of supervised probation, 300 hours of community service, a $50,000 fine, and mandatory participation in a fire safety community education program. No jail time. I won't lie to you. Part of me thought the sentence was light. Another part understood that Sandra had already lost things that mattered to her more than freedom. The development deal. The community standing. The HOA she'd built over 7 years. The house eventually sold at a loss. The name that had, for years, carried weight in Sycamore Pines. The community service component was notable. Sandra was assigned to volunteer with a Cal Fire Community Preparedness Unit. She was going to spend 300 hours helping people understand fire risk. Fire Marshal Carver told me about it with the slightly wry expression of a man who appreciated irony when it appeared in his case files. I said, "If she actually learns something, that's not the worst outcome." He said, "That's generous of you." I said, "It's practical." The civil judgment was paid in September, the HOA's portion, the legal fees, the damages assessment for the tampering. Priya's office received a wire transfer on a Tuesday morning, and she texted me a single emoji. A small fire. I smiled at it. She billed me nothing for the celebration. The two Pinecrest Lane family's civil suits against Sandra were settled out of court in October. I don't know the terms, sealed as part of the agreement, but both families were back in rebuilt homes by the following spring. I walked past their houses one afternoon when the oak trees were beginning to turn, and they looked like houses that had been rebuilt by people who'd decided, after everything, to stay. I understood that decision. I'd made it myself many times. Craig Witowski sold his 2 Sycamore Pines properties in November. Neither sale involved Faye Dunlap. The buyers were individual families, not developers, not short-term rental operators. One of them, a couple named the Nguyen's, called me 3 weeks after moving in to ask about my fire suppression system. I walked them through it on a Saturday afternoon. Their daughter stood on the fence and watched the sensor mounts with the intense curiosity of someone who finds physical things interesting. I told her what each component did. She asked about the pump housing. I told her about the pump. Her father said, "We want to build one." I said, "Good. I can help you start the permit." I kept the log running through October, daily system readings, weather data, any HOA communication, old habits. Carol finally pointed out gently that the log had become less a practical record and more a way of staying in the fight after the fight was over. She wasn't wrong. I closed the log in November. I kept the binder. It sits on my office shelf between a copy of the NFPA Wildfire Standard and a 7-year-old Cal Fire After Action report that was the first document I read when I started thinking seriously about what it would take to protect this ridge. Sandra's house was bought in December by a family from Arizona who had done their research and arrived with plans already drawn for a defensible space redesign, including a rooftop suppression system. They'd seen the news coverage. They'd read about what had happened on Pinecrest Lane. The husband, a structural engineer named Kevin Park, knocked on my door 2 weeks after they moved in and introduced himself and said, "I want to do what you did, but better." I said, "Better is good. Come in. I'll show you the plans." Kevin Park and I spent 4 Saturdays going through the system design. He had ideas I hadn't considered: secondary sensor configurations, a battery backup for the pump controller, a different check valve arrangement that reduced pressure drop at full flow. We filed his permit in January. The county approved it in 5 weeks. Tom came by for the installation walkthrough and said, "Your system was version 1. This is version 2. Kevin said, "What's version 3? Tom looked at me. I said, "Whatever we build next." The community preparedness presentation I gave with Cal Fire in September had produced, over the following months, a quiet ripple: 14 households in Riverside County had contacted the county building department about suppression system permits after seeing the coverage of the Ridgeback Road fire. Fire Marshal Carver tracked the number and sent it to me in a February email with a note. "This is what good documentation does." I printed the email and put it in the binder. The binder was now 2 volumes. Tom retired from his informal consulting role in February, not from helping me, but from the general availability he'd maintained for any HOA or fire safety matter that needed a professional opinion. He said he was going to spend more time fishing and less time being an expert witness. He said it with the slight dissatisfaction of someone who knows they won't actually follow through. 2 months later, he was at Kevin Park's installation supervising the pump mounting. Some people are built for a particular kind of work, and the work doesn't retire just because they do. I gave a second presentation in March at a regional fire preparedness conference in Temecula. The audience was larger than the September event, 300 people, including fire officials from 4 counties, several HOA attorneys, and a contingent from a state legislative office that was developing wildfire preparedness guidelines for residential communities. I talked for 40 minutes. I talked about the system. I talked about the fight. I talked about documentation, permits, legal process, and the importance of building things that are right even when someone tells you they're wrong. I didn't mention Sandra by name. The case was in everyone's search history. The name didn't need to be said. A woman approached me after the Temecula presentation who introduced herself as a researcher at UC Riverside studying community fire preparedness behaviors. She said she was interested in the Sycamore Pines case as a study in what she called preparedness resistance, the social and institutional forces that push back against individual fire safety investments. She asked if I'd be willing to participate in a research interview. I said yes. We talked for 2 hours. She said at the end, "The thing that struck me most is that you won and it still almost didn't matter. The system almost wasn't there." I said, "The backup array was there." She said, "The one nobody knew about." I said, "The one nobody knew about." Carol started a vegetable garden on the south side of the house in spring, tomatoes, peppers, herbs, a row of strawberries that took over their designated space and sprawled into the walkway by August. Sounds like a small thing, but it wasn't. For 2 years, everything we'd planted in this place had been in the context of whether we'd keep it. The garden was something different. It was the kind of planting you do when you've decided that the future of this place is where your energy goes now. Marcus visited in April, his first time home since the fire. He walked the whole property, the fence line, the sensor array, the tank housing, and then walked Pinecrest Lane and stood for a while in front of the rebuilt houses. When he came back, he sat on the back porch and didn't say anything for a few minutes. Then he said, "You built something that worked." I said yes. He said, "I didn't understand that when you were building it." I said, "You were 29 and living in Portland. You weren't supposed to." He said, "I do now." I said, "Good. Help me design version 3. He got out his laptop. The oak tree in the backyard made it through the fire season with some scorching on the west-facing bark that faded by summer and disappeared by fall. By the following spring it was indistinguishable from the tree it had always been. Same height, same crown spread, same habit of dropping acorns on the roof in October in a pattern that sounded exactly like someone throwing small rocks. Carol has complained about the acorns for 9 years. I have done nothing about the acorns for 9 years. Some things you protect and some things you let go. The HOA's new board, Phil, 2 new members elected in October, Carmen Reyes, who joined after her system installation, and the Nguyen husband, who'd gotten his permit in January, held its first full-year review meeting in April. Phil sent me the minutes. The agenda included budget review, landscape contract renewal, amendment to defensible space guidelines, and a new item he'd added at the end, formal establishment of a Sycamore Pines Community Wildfire Preparedness Committee. The committee was empowered to advise homeowners on suppression system installation, coordinate with CAL FIRE's Community Liaison Program, and maintain a community-wide inventory of fire safety improvements. The first chair of that committee, elected by the board, was Tom Cafferty. Tom texted me about it at 9 p.m. after the meeting. I thought I was retired. I wrote back, version 3. I ran the annual system diagnostic in May, the full sequence sensors to pump to array. Primary, 100%. Backup, 100%. Tank, 98%. I logged it. I photographed the gauges. I filed the documentation. 18 months of HOA dispute, 1 criminal trial, 2 civil proceedings, And one actual wildfire later, the ritual of checking the thing I'd built remained what it had always been. The clearest way I knew to say that this place was worth protecting, and that I intended to protect it, and that no one was going to tell me otherwise. What I think about, more than anything else from those 2 years, is the relay switch. The bypass position. The thing Sandra had told Osman would make my system decorative. I think about how close it came. Not the fire, which I'd prepared for, but the sabotage, which I hadn't fully prepared for, which I'd found by accident because of an anonymous email from someone whose conscience had apparently set a minimum. I think about what would have happened if Ron Feltner's nerve had held, if he'd never sent that email, if I'd walked into the fire season with a system that looked perfect and did nothing. The math on that night is not comfortable. I don't do the math often, but I do it sometimes, usually on evenings when the sky goes amber over the hills and the sensors on my fence line are reading the temperature and the wind and doing the thing they were built to do, which is pay attention so that I don't have to pay attention every second. That's what I built. A thing that pays attention. That's what Sandra tried to take away. That's what I kept. The anonymous email, the one that came the Tuesday night before trial, that sent me out to the utility panel with a flashlight, was never definitively traced to a sender. The Nordghost subpoena led to Ron Feltner's IP, but Feltner denied sending it, and the DA's office, already having his full cooperation on everything else, didn't press the point. Tom has a theory about who sent it that I've never been able to confirm or deny. He thinks it was Brenda Kowalski. He thinks she knew what Sandra had done, couldn't live with it, and found a way to warn me without attaching her name to it. Brenda, when I asked her once, indirectly, whether she'd known about the panel, she said, "I knew something had been done. I didn't know what." She looked out the window when she said it. I never asked again. There's a plaque now on the west fence, next to the primary sensor array. The Sycamore Pines HOA installed it. Phil organized it, the new board approved it unanimously, and Kevin Park designed it because it turns out he does some graphic work on the side. It reads, Ridgeback Ridge Community Wildfire Defense System, installed 2021, activated August 2023. This system protected the structure during the Ridgeback Road fire. Dedicated to everyone who builds what matters and refuses to stop. I didn't write it. Phil wrote it. I didn't ask him to. I stood in front of it the morning they put it up and felt something I'd been waiting to feel for 2 years, which is the sense that a thing had been recorded accurately in a place where people could see it. The record mattered. The record always mattered. That's why I kept every document. That's why I'm telling this story. The END.